Good morning. I'm Judge Tammy Long Hayward. This is April 15th, 2025. This is the jail and Tuesday arraignment calendar for courtroom 304, State Court of Clayton County, Georgia. I'm going to call the arraignment calendar first because we only have one case on that calendar, and I do see that individual is here. Mr. Jesse Deocean Morris. Mr. Morris is represented by Lister Holton Dennis.
Good evening, Judge.
Hi, how are y'all?
Good
I'm
morning.
blessed.
So I did speak with private counsel on this case, and he is represented, Your Honor.
Okay, do we know who's representing him now? Mr. Morris, who's your new attorney?
Taz Taylor.
But no, it seems like you got private counsel. Who did you speak with, Ms. Ponder?
Your Honor, I spoke with Mr. If I could just have one moment.
Uh-huh.
I think I spoke with Attorney Dark, Your Honor.
Oh. Mr. Morris?
I'm sorry, Your Honor. It is
I think that was Mr. Morris's case.
Mother's.
Yes.
Okay.
That was Mr. Oh gosh, I can't remember his name right now, but it wasn't Mr. Morris.
Okay. I'm sorry, Your Honor. That is correct.
Okay, no problem. Mr. Morris, you have Taz Taylor. Mr. Taylor is present. Mr. Taylor, I'm sorry about that. Tell me what's going on.
Your Honor, Mr. Morris, this was continued previously because Mr. Morris needed to attend the funeral, but we're prepared to enter a guilty plea to the single count of DUI per se.
Okay.
And the state has offered to drop the other charges based on a plea to that count.
All right. So is that count one or count two?
I don't have, one moment, Sean.
Because it's not designated on my calendar. They both say DUI.
I believe that's count one, Your Honor.
All right.
Is that correct, Ms. Ponder?
Yes, that's correct.
All right. So Mr. Morris, let me see you if you can. I'm gonna send you a prompt. Helps.
I'm trying to figure it out.
Hold on. Let me send you this, and that might help you. You see something that pops up?
Yes, ma'am.
Okay. There you are. All right. So Mr. Morris, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, Judge.
Okay, you can put your hand down, sir. Thank you. You're before the court on State of Georgia versus Jesse Deocean Morris, 2021 CR 07922, for driving under the influence count 1, DUI count 2, improper lane change count 3, and no tag or expired or invalid tag. Now, you're represented by Attorney Taz Taylor with the law firm of Lister, Holt, and Dennis. And Mr. Taylor has indicated you're entering a plea of guilty to count one, which is the DUI per se. Counts 2, 3, and 4 will be no cost. By entering this plea, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, Judge.
All right. Factual basis and recommendation, Ms. Ponder.
Yes, Your Honor. On December the 9th, 2019, officers responded to Highway 42 and Rock Cut Place located here in Clayton County, Georgia. When officers observed a vehicle swerving without signaling twice before slowly swerving back in its original lane, officers made contact with the driver of that vehicle and smelled a strong odor of alcohol coming from his breath. When officers continued to investigate, officers did learn that he stated it was his birthday week. I asked him if he was okay. He stated that if he had been drinking, He indicated that he consumed 2 shots of Hennessy 2 hours ago. Officers at that point did conduct a standardized field sobriety evaluation and later determined that he was in fact less safe to drive. Officers read Georgia implied consent in which the defendant consented. It came back to his BAC was
0.21. 0.21, Your Honor.
0.215. Those are the facts of the case, Your Honor. And then the state's recommendation is as follows.
What, 500?
Okay. The state's recommendations, 12
Your
months to serve 12 months to serve, 24 hours credit for time served, balance suspended, a $500 fine, 40 hours of community service, substance abuse evaluation, any recommended treatment, enroll and complete a risk reduction course, no drugs or alcohol, and subject to random testing. And I'm not sure if I said 40 hours of community service.
You did. All right, Mr. Taylor.
Thank you, Your Honor. One thing I would like to point out is that this is a 2019 case, so it's been 5 years. Mr. Morris has taken accountability for his actions on that day, but we just ask that the court accept the recommended sentence.
All right. So, Mr. Morris, on that day, what you did was reprehensible. You could have hurt yourself. You could have hurt someone else. You could have killed someone. But I recognize that it's been quite some time since that day. And I don't have anything else pending before me that says that you did anything similar to this. So it is apparent that this was a lesson learned. I'm going to ask that you make sure that you complete all of the probation requirements. If you have any difficulties, make sure that you communicate with your probation officers. They are here to make sure that you complete everything successfully so that we can put this behind you, okay?
Yes,
All right.
ma'am.
So I'm going to accept your plea of guilty to count 1. Counts 2, 3, and 4 will be no pros. I'll sentence you on count 1 to 12 months to serve 24 hours credit for time served. Balance will be suspended as balance will be probated for you to pay a fine in the amount of $500, 40 hours of community service. You're to take a substance abuse evaluation and any treatment that may be ordered. You'll present that information to probation. You'll present completion of the risk reduction course to probation and have no alcohol or illicit drugs during the course of the 12 months. And you're subject to random screens for alcohol and drugs. Do you understand?
Yes, ma'am. Yes, Judge.
You have any questions, sir?
No, ma'am. No, Judge.
All right. If you have, what I'm going to do now is put you in a breakout room with our probation expert. With Miss James. So Miss James is going to get you enrolled in probation. She'll answer any questions that you might have. Anything else that comes up, you are always free to ask your probation officers. Now, the one thing I'd say, and I'll caution everybody about this, the quickest way to get rearrested is to not appear for your probation reports. Everything else, something happens, you can't get something done, they'll let me know. But if you don't report for your probation, I will definitely get an arrest warrant. You understand?
Yes, yes, Judge.
All right. Thank you, sir. All right, Mr. Morris, I'm going to put you in a breakout room with Miss James. Once you've spoken to Miss James, you don't have to come back here. Just go ahead and get started on your probation. All right?
You say I will have to come back there?
No, you don't have to come back into this
okay.
main room. Once you speak to Miss James, she can excuse you from the hearing.
Okay. Thank you.
All right. Take care, sir.
So type on the join.
Yes.
What you just sent. Thank you.
All right. Thank you so much. Okay, now we're going to go to the jail calendar. What I want to do first is just for the ease of, I think all of us, let's go ahead and go through the jail calendar and just call the calendar. I think that helps Ms. Park too. And then we'll come back and do any pleas or any petitions that are ready. Okay, just give me one moment. All right, so I'm ready to call the calendar. I see somebody is listed as iPhone. Please make sure you put your first and last name. Oh, it's Miss Cooper. Miss Cooper, I'll change that for you. 1 second.
Thank you.
No problem. Thank you for that. All right, so that. All right, so ladies and gentlemen, the jail calendar, first name on the calendar is Kiera Simone Archie. That's a petition. Kiera Simone Archie. Ms. Chang, you're ready. Is anybody in the courtroom spoken with Ms. Archie? I think y'all are muted.
Good morning, Your Honor.
Good morning, Ms. Chang.
With regard to Ms. Archie, I'd like to speak with the attorneys regarding this case
Okay,
in a breakout room if possible.
sure. All right, so
Thank
I will set that up.
I
thank
received
you.
the petition from Ms. Chang, but I haven't spoken with Ms. Archie yet.
Okay, so let me go ahead. I'll put y'all in a breakout room at the appropriate time, and then I guess if you need to speak with Ms. Archie again after that, that's fine too.
Thank you.
All
Thank
right.
you, Your Honor.
Anthony Jerome Bowie.
Judge, that is on the calendar for a motion to set bond, which we are prepared to go forward on, although I have spoken to Ms. Ponder about the potential for a consent bond. And I think she's open to that. If I could just have a moment and announce whether we're going forward or whether we want to present something to Your Honor to perhaps consider to do by consent.
All right, that's fine. All right, the next case is Dontavius Marcel Green.
Judge, that's going to be a negotiated plea today.
All right. Blondie Harris.
Judge, I believe we haven't spoken to the female inmates yet.
Okay, no problem. Michael Sean Lassiter.
Your Honor, Mr. Lassiter has 2 cases and we anticipate entering a plea to both cases today. A guilty to the simple assault case 03319 and a NOLO plea to the traffic violation case 03369.
Okay, gotcha. All right, Lockwood, Theodore Bartley, Lockwood.
Your Honor, we're just waiting to speak with Mr. Lockwood. We'd ask the conference and give an announcement at the end of the call.
Okay. Antoine Marquise Martin.
Morning, Your Honor. I'm Sasha Minutes on behalf of Mr. Martin. We have a negotiated plea. I just need a few minutes to go over his rights.
All righty. So we'll come back and we'll do the plea while the Lister Holt and Dennis are talking to some of the other inmates.
Yes, thank you.
All right. Shakia Renee McKnight. Oh,
I believe Ms. McKnight is out the bond, Your Honor.
okay. Y'all know Miss McKnight is one of my frequent flyers. Lord bless her heart. Oof, okay. Marquelius Teray McNabb. Marquelius Teray McNabb.
Judge, Mr. McNabb is present in the courtroom. That is on today on the state's motion to revoke bond. Judge, I am trying to negotiate a resolution with Ms. Ponder. But in the event that that, does not materialize, we're ready to go forward with I mean, I guess the state, but I believe the state's ready to go forward.
Yes, Sharon, the state is now saying ready if it doesn't have a resolution.
Okay. Joshua Lee Mitchell.
That's the one.
Your Honor, Mr. Mitchell, I'm sorry. Mr. Mitchell refused to come up this morning.
We got some concerns, or is he just being ornery?
I think he's been ornery. The charge is theft by shoplifting. I would anticipate that.
That's infinitely resolvable, but if he doesn't want to see me today, we'll reset him till next week
Thank you, Your Honor.
or the next calendar,
Yes.
next Tuesday calendar. All right, Myers, Corey Takevius Myers.
Your Honor, I spoke to Mr. Myers. He wishes to enter nolo to this case. I'm discussing with the state possible global resolution with his other misdemeanor case.
Okay, I don't see the other one on here, but y'all can add that, right?
He has previously entered a not guilty to the other case. This is his first arraignment on this
On
case.
this one. Okay, no problem.
Your Honor, if Mr. Myers decides to enter a plea or accept the state's offer, I will see if I can get that other case pulled so that he can resolve his cases today, so there's not anything outstanding. It'll be a global offer.
Yeah, that's fine. Thank you. Gabriel Sheely. Oh, I'm sorry, Jalen Danielle Perez. I remember, I missed Perez.
Ms. Perez is out to bond, Your Honor.
Okay. Next is Gabriel Sheely. Gabriel Sheely.
Judge, I believe.
And Your Honor, that is on the calendar for a motion to revoke bond, Your Honor.
Mm-hmm.
And so the state is requesting, if the defendant is not present, the state is asking for the court to grant the state's motion. Oh, he's present? Okay, well, the state is ready, Your Honor, in this case.
Okay. So we'll hear that. And DeMarco Trammell.
Yes, Your Honor, that will be a no low plea today to the 3 counts.
All right. And next is Jerome Dexter Whitaker Jr.
I need to talk to you about him. Judge, that will be a plea today. I believe it'll be a negotiated plea. I just have one question to ask Ms. Ponder about that, but I believe in any case, we'll have a negotiated plea.
Okay. Salah Whitlock.
Yes, Your Honor, that's a female that I need to speak with. However, I anticipate that this will be a plea today, considering the nature of the charge and the recommended sentence.
Okay. And last case on the jail calendar is Williams, Quentin Lamar Williams.
Your Honor, Mr. Williams is out to bond, but he is present in the courtroom and wishes to enter a no low plea today.
Okay, that's fine. Thanks, Mr. Williams. You made that easier for us than having to reschedule. All right. So a lot of things y'all have to talk about. Ms. Chang wants a breakout room with Mr. Taylor. And then I'll give y'all a few minutes to negotiate. And then when we come back, we'll go ahead and start taking pleas. But first, before anybody goes, Mr. Martin's plea.
He is, he's out to bond.
Oh, he's not here.
So Antoine Marquise Martin.
Yes. Yes, sir.
A few minutes. Nobody's up yet. Got it.
Good morning, Mr. Manetas.
Morning, Your Honor.
Okay.
Good morning, Mr. Martin.
Good morning, Miss Haywood. How are you doing, Your Honor?
I'm good, sir. Mr. Martin, can you put your right hand up for me, please?
Yes, ma'am.
Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand down, sir. You're before the court on case 2025 CR 03229 for criminal trespass count 1 and public transit violation count 2. You're represented by Attorney Menadas, who's here with you. Mr. Menadas, what is your client plead to the offenses before the court?
Your Honor, we'd like to present a negotiated guilty plea to this honorable court.
Okay, on both counts?
Yes, Your Honor.
All right. So, Mr. Martin, by entering a plea of guilty to count 1 and 2, sir, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And Mr. Martin, if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Can you repeat that? Because I've been a citizen since 2000.
No, sir, I tell that to everybody. I don't ask whether you're a citizen or not. I just make sure everybody has the same information, okay?
Okay. Oh, you should state in facts. Okay.
Yeah, I'm just telling you what this plea means and the fact that if that was a concern for you, then I have to give you that information. No, sir, it's not you specifically. I say the same thing to everybody.
Oh, yeah. Okay. Okay. That's cool. That's cool. Hey, look.
All right.
Look.
So by entering these, so did you understand everything now that we've clarified that?
Heard.
Okay. All right. So factual basis and recommendation, please.
Yes, Your Honor. And if you can't hear me, let me know and I'll move closer.
Oh, I can hear you.
On February 25th, 2025, officers were patrolling the area at the MARTA Airport Station. Officers observed the defendant, later identified as Mr. Martin, push his body weight against the fare gate to avoid paying the $2.50 to ride. Officers made contact with that individual and noticed that he had a 365-day suspension that was issued on September the 2nd, 2025, and it was effective until October the 2nd, 2025. Those are the facts of the case, Your Honor. The state's recommendation is to dismiss count 2, the public transportation tokens/tickets, and he will plead to count 1, criminal trespass. State's recommendation is 12 months to serve, 50 days credit for time served, balance suspended. Do not return to that location.
All right. So, Mr. Martin, the state is going to null pros count 2. So you're entering a plea to count 1 only.
Yes,
And
Your Honor, sticker there, sorry.
Okay, no problem. And for count 1, it's 12 months to serve, 50 days credit for time served. Balance will be suspended as long as you do not go back to the incident location and as long as you do not have any other violations of the laws of the state of Georgia, okay?
Okay. God bless you.
Thank you, Mr. Martin. God bless you too.
Okay. I'm just make sure I'm coherent. One more thing.
Yeah.
Restitution. What does that mean? Like, what's the definition of it?
Oh, so restitution would mean if you hurt someone or took or damaged their property, you would have to pay them back. But you don't have any restitution in this that I'm aware of.
Okay, I like that. I like that.
Okay, so you're good, Mr. Martin. You're good to go.
All right, thank you, Judge. And one last thing, since he is supposed to be released today, and I know there's sometimes a delay with the classifications. Is there anything?
Look now, Mr. Menadas, what you're not gonna do is get me talking about what goes on at the sheriff's office. According to me, he's free as of today. I don't get involved with all of that.
Thank you, Judge. I guess what I'm asking is if I could be emailed the disposition, I'll take it over to the classifications, just in case. I know that helps.
Sure, if we send it directly to them, but you can actually get a hard copy if you want to. Just go to the second floor to the traffic court window and they'll print you out one.
Okay, thank you, Judge.
No problem.
Does the court have my email in case someone can email it to me?
I
No,
don't
sir, I
have
do
it.
not have your email. I looked for it before court and we don't have it on record.
Okay,
Okay,
so can you give it to us now, and Miss Wright will go ahead and do that for you.
Yes, Your Honor, thank you. It's my initials AM at MANETTASLAW.com. My last name in law and then .com.
Did you get that, Miss Wright?
That's A as in apple, M as in mother at manetaslaw.com.
Yes, ma'am, that's correct.
I got it. Thank you. I'll put that in the in your records.
All right, thank you. And Your Honor, may I be excused?
Yes, sir. Thank you.
Good to see you, Judge. Thank you.
All right. All right. So, Mr. Taylor, Mr. Lynch, I know we got a couple of motions. We got a bond revocation petition, and we also have pleas. Now, y'all have pretty much worked through the pleas. I know y'all still have to speak to the females. I'm going to give y'all some time to go ahead and get this done. I'm going to update my calendar as to who's still pending and who's not here. Did you have something for me?
Your Honor, there's one case that's not on the calendar that I've discussed with the state. It's Marisha Cooper. She had an outstanding bench warrant because of an address issue and getting noticed.
Okay.
I'd like to resolve her case today. So we're ready to proceed forward. I believe the state may be-
Does she have, do we have her information, like her case number and everything?
We do, Your Honor. It's case 2021 CR 08269. And it's a single count of shoplifting.
Okay.
And I believe the address issue was my fault. She gave me her address as Columbus, and I thought that was Columbus, Georgia. I believe it's Columbus, Ohio.
Oh, okay. All right. So, let's go ahead. Are y'all ready now, or did you need some time?
Yeah, I'm still trying to retrieve that case now. Ms. Arnold is out today, so I just had to request it from another legal assistant, but we're trying to get that file now.
Okay, so Ms. Ponder, I'm getting feedback that maybe I can hear you, but I don't think you're clear when it comes to Ms. Martin doing takedown. So if you could just go to a microphone, that would be good. And then I'll give y'all, I'm gonna give y'all some time to work through all of this, and then we'll come back, okay?
And Your Honor, for the hearings, I will be in my office.
Oh, that's fine.
I'm down here to speak with counsel about the cases on the calendar.
Yeah, that's fine. Thank you.
You're welcome.
Do you need anything more from this one?
No, I'm about to just go get it.
Okay.
All right, so.
All right, y'all let me know when y'all ready for announcements.
Mr. Williams, since he's present. He is. He's on the jail calendar. He's present. So
Oh, okay.
we can get that wrapped up as quickly.
Did you get all the information you needed from him? Or no? You did? Okay. You want to do that now? Okay, I'm ready.
The judge is ready.
Yeah, I'm ready if you are.
Your Honor, while we are waiting for the females to be brought into the visitation booth, if we could resolve Mr. Williams, Quentin Williams' case on the calendar since he's present in the courtroom.
Do you know when he pointed out? When Mr. Williams pointed out? Okay. I was trying to figure it out. Okay. All right, I'm ready.
She started on probation. And the signatures. I can email this to
Sir. Sound this way.
So this one is a little complicated, but we don't know. So this is what she prepared to. Not all at once, but. Stay in there, verify it together, and send it over to CPAS. This is.
It has happened. Yeah. That happened in Alabama, so after all this.
Which is the same letter.
Is this the person not working anymore?
Exactly. And this is the email, and this is Mr. Chiffon. Supposedly. Signed off on all these.
You sat down and one setting and one was two pieces.
And it's the same, it is the same letter all along that she kept providing with just a, there's a number of.
It's very professional.
It does. So at the end, she provided, the last letter is when I called CPAX. I first talked to Mr. Shell.
And the CEO wrote a letter.
Forward to both of you and forward to the judge.
Okay.
And then tell them. Call this person for proof. And he called me and I called him back. This was our intention. He sent me supposedly. But he sent me the same letters that she had provided, except for this one. He said this one, that was rejected. With a copy of the log, which is also the work account. She was on probation back in January. So.
Well, I'm in the same position as you are, because at this point, this was just, when I was asked to speak to the judge, at this point, it's like falsifying documents, which could be lead to a bigger issue. Because it's not, I've seen it where people write their name. It's like, okay, you got caught, but it's like you're going above and beyond to, necessarily privacy allegedly, but
I
I
say
would say-
allegedly, but I think that falsifying, this is official government.
yeah. So, I just,
It's.
I mean, it looks good though.
Sorry. I just, I'm gonna push that out.
You are gonna get some pushback, so just be prepared, so that you send it over.
It's a possibility. Non-person certified.
Ooh.
That's
It opens like a bigger can of worms for everybody. Ooh.
And she said that she was on the police report, how that earlier this week or last week at home for to see if she had done so. Check.
the current.
They are, CPACs, and she said that they were trying to get that straight. Where the jurisdiction file.
It could be good, as it's not big, it's Wilson. I mean, not Wilson, but yeah. So it was sitting here working. I'm gonna speak to Mr. Rich about the case then. I'll be right with the officer Covington and then hopefully. Start this
Thank you.
You said something that. That he has phone records. He supposedly should not be there. But the thing is that he did see the same number for CPACs. You know, that's on their website. Why would he give that if he's not?
I'll tell her.
Bring this to trial. With the
That'd be fine. You know, I can have that. I know that's a valid one for us. Usually I can see, I guess it was the volume. Thank you, Your Honor. I've spoken to the females, and we are ready to proceed when the state's ready to proceed.
All right, Mr. Taylor. Let me put you, and you've spoken with Ms. Chang, that's right, correct?
With Ms. Chang and that probation situation with Ms. Archie's rather complicated. If we could hold that to the end of the calendar. I hate to waste Ms. Chang's time, but I believe she understands the situation that we're looking at.
Okay, no problem. All right, I'm ready. If we're ready to go forward. So we'll hold Archie until the end is my understanding. And then we have a few hearings.
Yes, Your Honor. If we could go forward with the females that are in custody, starting with Blondie Harris.
Okay, bring up Ms. Harris.
Aaron, I just have a question. Are you able to see me? Because I can't see myself and it's freaking me out.
Yes.
Okay, yeah, I see you.
Okay, you can see me? Okay,
Uh-huh.
great.
Usually mine is because I've hit that little switch at the top, but no, I can see you. All right, Blondie Harris.
She's coming in now, Your Honor. Ms. Harris? Ms. Harris? Over here.
Ms. Harris, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Right.
All right, you can put your hand down. You're before the court on 2025 CR 03498 for criminal trespass. You're represented by Attorney Taz Taylor. Mr. Taylor, what does your client plead to the offense before the court?
Your Honor, my client pleads no contest, nolo contendere to the single count of criminal trespass.
All right, by entering a plea of nolo to criminal trespass, Ms. Harris, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And Ms. Harris, if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, ma'am?
Mm-hmm.
All right, factual basis and recommendation, please.
Yes, Your Honor. On March the 24th, 2025, officers responded to 6000 South Terminal, which is the Atlanta airport. Officers observed a Black female later identified as a defendant before you. Ms. Harris, officers learned that the defendant did have a current and valid criminal trespassing warning. She was sitting in a chair near carousel 4 of the South Terminal. Those are the facts of the case, Your Honor. The state's recommendation is 12 months to serve, 23 days credit for time served, balance suspended, do not return to that location.
I got out of jail today.
All right, so Mr. Taylor, anything on behalf of Ms. Harris?
Nothing specifically, Your Honor. I have spoken to Ms. Harris about the circumstances that led to her arrest, and I've emphasized to her that she cannot go back to the airport unless she has a ticket to get on a plane, and she told me she understands that.
All right, so Ms. Harris, I'm going to accept your plea of nolo. I'll sentence you to 12 months to serve 23 days. Credit for time served, balance will be suspended as long as you do not go back to the Hartsfield-Jackson Atlanta International Airport unless you have a ticket for travel on that day, okay?
Okay.
All right, thank you, ma'am.
I got out of jail today.
Yes, I think so. Yes, ma'am.
Thank you.
I got out of jail today.
All right, who's next?
Whitlock? Your Honor, that should be Ms. Whitlock.
Okay.
Come with me. And here's the judge. Okay, so you see her, just we'll talk to that camera.
Okay. All right. Who's this?
This is Miss Whitlock, Your Honor.
All right, Ms. Whitlock, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right, you can put your hand down. So is it Salah or Saleh?
Taylor.
Sayla. I'm sorry. So Miss Sayla Whitlock, you're before the court on 2025 CR 0303501 for criminal trespass. Mr. Taylor, what is your client plead to the offense before the court?
Your Honor, my client pleads nolo contendere, no contest.
All right, Ms. Whitlock, by entering a plea of nolo, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of nolo or guilty could negatively impact your immigration status. Do you understand all of these things, Ms. Whitlock?
No longer.
Yes.
All right, factual basis and recommendation, please.
Yes, Your Honor. On March the 2nd, 2025, officers responded to 5969 Highway 42 in Clayton County, Georgia. When officers arrived on scene, they made contact with the defendant, later identified as Ms. Whitlock. Officers indicated that she was previously issued a trespassing warning earlier that day at 2300. Those are the facts of the case, Your Honor. The state's recommendation is 12 months to serve, 46 days credit for time served, balance suspended. Do not return to 5969 Highway 42, Rex, Georgia, which is the Exxon Mobil gas station.
All right. All right, anything else, Mr. Taylor?
I've talked to Ms. Whitlock and I've explained to her that she cannot go back to the Exxon on Highway 42. She told me she understands, can go back.
Yes.
And we just asked the court to accept her, the recommended sentence.
All right, does she have a place to go that we know of?
Do you have a home?
Yes, I have to go with my Aunt Evelyn.
With her Aunt Evelyn, Your Honor.
Okay, all right. All right, ma'am, just don't go back there. I'll send you to 12 months, 46 days, credit for time served. Balance will be suspended as long as you do not go back to the Exxon at 5969 Highway 42 in Rex, Georgia, Clayton County, okay?
Yeah.
All right, don't give Aunt Evelyn any trouble, okay?
Thank you, Your Honor.
All right.
And Your Honor, while they're bringing the mails up, if we could proceed with Mr. Williams, who's in the courtroom.
Okay. Come on up, Mr. Williams. Good morning, sir. Raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, Your Honor.
All right, you can put your hand down, sir. Mr. Quentin Lamar Williams, you're before the court on 2025 CR 03488 for disorderly conduct and obstruction of an officer. Mr. Taylor is with you at the podium. Mr. Taylor, what is your client plead to the offenses before the court?
Your Honor, my client pleads nolo contendere to both count 1 and count 2.
All right, sir, by entering a plea of nolo to counts 1 and 2, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence against yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, Your Honor.
All right. Factual basis and recommendation, please.
Yes, Your Honor. On August the 23rd, 2024, officers responded to 5060 Frontage Road, located here in Clayton County, Georgia. It is the Eco Lodge Hotel. Officers learned during the course of their investigation that the defendant did yell and kick doors at the Eco Lodge Hotel. He also had to be restrained multiple times. There were individuals who called for noise complaints, and he continued with his behavior. Those are the facts of the case, Your Honor. And the state's recommendation is as follows: 12 months for count 1, disorderly conduct. That's 12 months to serve, 30 days, credit for time served, balance suspended, do not return, and stay away from 5060 Frontage Road, FRONTAGE Road. Zip code 30297. For count 2, it'll be a $300 fine, suspended.
Okay, on the frontage road address, which municipality is that?
I believe that's Forest Park, Your Honor.
Okay, thanks. All right, so Mr. Williams, I'm going to accept your pleas of nolo. On count 1, I'll sentence you to 12 months to serve 30 days, credit for time served. Balance will be suspended as long as you do not go back to 5060 Frontage Road in Forest Park at Georgia, Clayton County during the 12 months. And no, and on count 2, a nolo $300 suspended fine. Okay. At this time, you're free to go, sir. You know the circumstances that got you into this situation, so please be mindful of that and let's not repeat it, okay?
Yes, Your Honor, and I just would like to add on that I am in recovery since that, and today's 6 months and 18 days sober for me. So I have.
Woo-hoo!
Thank you so much, Your Honor. That means a lot. So I have turned my life around and flipped a new leaf. I just want to let you know that.
Okay, well, you know, the journey for sobriety is a journey. It is not I'm gonna get there and I'm gonna stop.
Yes,
But you're doing amazing on that journey. You look good, you sound good, and I'm proud of you. So continue on, okay?
Thank you, Your Honor. It means a lot. Thank you so much.
All right, take care, sir.
Enjoyed it.
And Mr. Taylor, I have retrieved the Cooper file, and I also have Mr. Myers' other file in case he wants to resolve his other case. And then I do have Ms. Cooper.
Your Honor, if we could address Ms. Cooper's case since she's online and we're ready to proceed.
I'm ready when y'all are.
I'm ready, Your Honor.
Ms. Cooper, they have your case ready. So I'm gonna let's see, send you a prompt so I can see you, okay?
And Your Honor, I just have I'm so sorry for cutting off the court. So one of our witnesses for the McNabb case is currently in training, but he was able to get out for his lunch. So he has logged on. He's on lunch for about an hour and 15 minutes. And so we were just trying to
I'm
see
ready
if-
if y'all are ready, right? Y'all want to go ahead and do Ms. Cooper first and then go ahead and do the motion for McNabb?
Yes.
Okay, that sounds good to me.
And the
all
other
right.
officers in the courtroom, Your Honor.
Okay, that's fine. All right, so I have Ms. Cooper. Ms. Cooper is before the court on 20, I'm sorry. It was up here. Where did it go? All right, 2021 CR 08269 for shoplifting, Ms. Marisha, Marissha Cooper.
It's I'm sorry,
Go ahead.
Marrisha.
RRIS. 2 S's or 1?
Just one.
Okay, I'm sorry. I wrote that down all wrong. Marrisha.
Yes,
All
ma'am.
right. Thank you. All right. So, Ms. Cooper, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true. All right, you can put your hand down. So you're before the court on State of Georgia versus Marisha Cooper, 2021 CR 08269. You're represented by Attorney Taz Taylor, who's with you here on the call. Mr. Taylor, what is your client plead to the offense before the court?
To the single count of theft by shoplifting, Ms. Cooper pleads guilty.
All right. By entering a plea of guilty, Ms. Cooper, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, ma'am?
Yes, ma'am.
All right, factual basis recommendation, please.
Yes, Your Honor. On June the 2nd, 2021, officers responded to 7050 State Route 85, Riverdale, Georgia, 30274, which is the business of Walmart. Officers learned after speaking with loss prevention, officers did observe that the defendant did go through a self-checkout register and scanned several items totaling to $65.09. The state's recommendation is as follows: 12 months probation, to enroll and complete a theft prevention course, 40 hours of community service, and there is a fine, Your Honor, but the state will, I know it was communicated to council, there was a fine, but just due to the charge and I'm gonna remove the fine, Your Honor, so it'll just be community service and the theft prevention course.
All right, Mr. Taylor?
Thank you, Your Honor. We just asked the court accept Ms. Cooper's plea under the First Offender Act.
All right, so
Ms.
Ms. Cooper, go ahead, I'm sorry.
I've spoken to Ms. Ponder, and I believe our client qualifies.
All right,
Yes,
so
Your Honor.
Ms. Cooper, I'm sure your attorney has explained to you how important it is that you successfully complete your probation. You only get one shot at the First Offender Act, and so that will make sure that this old useful indiscretion, which I'm sure you have not repeated and will not repeat again, will not affect you in your life, okay? So please make sure you do whatever is necessary to successfully complete probation. So it's 12 months probation, a theft prevention course, and 40 hours of community service. Once you have completed the theft prevention course, go ahead and make sure your probation officer has that proof, the 40 hours of community service, make sure they have that. And I'm open to termination upon completion if you all don't have a problem with it.
Your Honor, I would just defer to the court. In addition, Your Honor, she does have a bench warrant, so I will prepare a bench warrant recall.
All right, thank you.
Again,
All right,
welcome,
so
Your Honor.
I
Thank you.
apologize for that because that was me getting Ms. Cooper's address incorrect.
I got you. So Ms. Cooper, once you have completed the terms and conditions of probation, then I will allow your probation to terminate, which means that the quicker you get it done, the quicker you'll be off probation. The thing that you need to know is failure to appear for probation reports can jeopardize your first offender status, and it could end up with an arrest. So you don't want to do that. You want to make sure that you can. You said she's in Ohio. Is she going to be able to appear, or does she need phone and mail?
Can I have the mail?
I'm sorry, Mr. Taylor.
I was just asking Ms. Cooper to answer your question.
Ms. Cooper, you still in Ohio?
Yes, ma'am.
All right, so Ms. Cooper, I promise you, this is the easiest way to do it. Get 12 stamp addressed envelopes, address them to probation. Get 12 copies of the form that they're going to give you. Make sure that when it's time to fill them out, you drop them in the mail. Fill them out, drop them in the mail. We clear?
Yes,
Do
ma'am.
not miss your probation reports because that's the quickest way to get rearrested. And you want to successfully complete this so that it can make sure that your record is cleared up afterwards, okay?
Yes, ma'am.
All right, so I'm going to put you in a breakout room with Miss James. Miss James is the probation expert. She's going to be able to explain everything to you. She's going to be able to answer any questions that you might have specific to what you're doing. And please ask those questions. And once you're finished speaking with Miss James, you do not have to come back to the main room unless you have a question for me or for your attorney. But you're free to go at that time. Just make sure that you complete whatever's necessary for probation, okay?
Okay, thank you.
All right, I'm going to put you in breakout room number 6 with Miss James.
Yes, ma'am.
All right, thank you, ma'am. And spread the word. It ain't worth it. All right, so next is McNabb. Motion to revoke.
Your Honor,
Yes.
I do represent Mr. McNabb, and I just wanted to,
And I'm sorry, Your Honor, can we have a breakout room with Mr. Lynch? We have a negotiation. I just need to ask about if the court will accept.
Okay, hold on.
I could potentially save some time there.
Uh-huh.
At this point, Mr. McNabb is not accepting the recommended, the newly negotiated recommendation that you presented, Ms. Ponder. So I don't know if that,
Okay, so that means we're going forward with the hearing.
that is my understanding, Judge. I just don't want to waste anybody's time. That's
All right, let's go forward. All
And
right,
Your Honor,
so.
can I have a brief breakout room with the officer, Mr. Angeles, please? Officer Angeles?
Yes, I'm here.
Yes.
Don't want to interrupt, but so the state did file 2 motions to revoke bond, and I'm just trying to figure out which one we're going forward on first.
Well, how many cases does he have?
Yes, 5, Your Honor.
Okay. Oh, yeah. All right. So, let me put, are you going on forward on both? The second one, the first one, what y'all doing?
We're going forward on both.
But I'm just trying to figure out which one we're starting with.
I'm just want to speak with the officer. I believe, and I can tell you which case he's on because he's the one that's in training. Then we have another officer that's been here and he's in the courtroom.
Okay.
And then we have another victim that's on the call, Miss Bailey. So I just need to speak.
Okay, breakout room number 1.
Thank you.
You're welcome. We'll be back.
State is ready, Your Honor. Your Honor, we're gonna,
Do you know which one we're going?
yeah, I'm
which-
about to tell you that right now because it all comes down to dates. So we're gonna go forward on the first one on the calendar, and that's the 2022 CR 00704. And that is the simple battery and terroristic threats. Then we're gonna follow up and do the simple assault, and Miss Bailey is on the call for that case, as well as Officer Covington, who is still in the courtroom. He is on the 2024 CR 00633. He is the officer for that case. The victim, Miss Bailey, is on for that case. And then the first one, 2022 CR 00704. I can use both cases, but I'm gonna use this officer here, Mr. Officer Angelus, excuse me.
Can I?
All right.
Can I, Ms. Ponder, I understand the procedure. I'm gonna chat you something.
Okay.
I'm taking a look at it. It may or may not be an issue here, but I think it's in regards to the motion. And I just want to make sure you're understanding this.
Okay. Now let me pull the chat up 1 second. Okay. Yes, it's the sister. Correct. Am I right?
The August 2023 case is Chartria, which would be the mother of his children, the sister.
Correct. So the cases on the calendar is against the mother of his children. The case from the battery family violence case, I have Shankiria and Shataria Hutcherson for both as victims.
It's just, the allegation is just that for the 2020, for the battery family violence case, August 17th, 2023, the only victims are alleged would be Chartria. There's not Shakiria. So in the motion, it says Shakiria is the victim on the August case, but that's not what's alleged, and that's not what the police report.
So my motion is based on the fact that your client picked up new cases when his bond conditions in 2021 said do not violate any other laws while on bond. So that's why we're going forward.
Right. It's not just, and I understand that.
So it's just not victim based, correct? Because she's not going to come up here against her child's father, I'm sure.
Okay. I just wanted to make sure that we were.
Yeah, no, I'm aware. Yeah, I was speaking to the officer about that. So we had kind of an understanding.
Okay, I guess I don't, and I apologize for taking time. I just wanted to make sure we understood that.
Are we ready?
Defense is ready.
All right. So this is the motion to revoke bond on case 2022 CR 00704. This is Marquelius Teray McNabb. Ms. McNabb is represented by the law firm of Lister Holt Dennis. Mr. Owen Lynch is with him. The state is represented by Deputy Chief Sharia Ponder. And they are ready to go forward with the motion. Ms. Ponder, you may call your first witness.
Thank you, Your Honor. At this time, Your Honor, the state is going to go out of order with witnesses based on officer availability.
That's fine.
Thank you, Your Honor. And so at this time, Your Honor, the state will call Trooper Angeles. May you please raise your right hand? Do you swear or affirm that the testimony that you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I swear.
Okay, may you please state your first and last name?
Trooper Ulysses Angeles.
Okay, and can you spell your first and last name for the court and for the reporter?
First name is Ulises. Last name is Angeles, Angeles.
And how are you currently employed?
I'm currently with Georgia State Patrol.
Okay, and prior to being employed with the Georgia State Patrol, were you employed with the Clayton County Police Department?
Yes.
Okay, and how long were you employed with the Clayton County Police Department?
Approximately 4 years.
Okay, and being employed with Clayton County Police, does it require you to be post-certified?
Yes.
On this date, August the 17th, 2023, were you in fact post-certified?
Yes.
In good standing?
Yes.
Okay. And being post-certified, does that give you the authority to issue citations?
Yes.
Does it give you the authority to arrest individuals?
Yes.
Okay. I want to draw your attention to why we're here today, August 17th, 2023. Did you respond to 7830 North McDonough Street,
Yes, I did.
located here in Clayton County, Georgia?
Yes.
And why did you respond to that incident location?
I responded in reference to a domestic violence call.
Okay. And during the course of your investigation, when you arrived on scene, did you make contact or did you speak with anyone? Without saying what they said, did you have a conversation with anyone on scene?
Yes.
Okay. And how many people do you recall speaking with?
I spoke to Mr. McNabb. I also spoke to his girlfriend at the time, which Chartria. Last name was Hutchison, Chartria Hutchison, and her sister, who was also present. Her name is Shakiria Hutchinson.
Okay. And so, I just want to understand correctly, because I know there's a lot of information. Give me one moment. Okay. And so during the course of your investigation, you indicated that you spoke to 3 individuals. Did you speak to anyone else?
Yes. It was a 9-year-old and a 7-year-old juvenile on scene as well.
Okay. And you spoke to the 2 children and the 3 adults.
Correct.
Okay. In the course of your investigation, after speaking to those individuals, did you make an arrest?
Yes.
Okay. And who did you arrest on that day?
Mr. McNabb.
Okay. And what did you arrest him for?
For battery, family violence, and cruelty to children, 3rd degree.
Okay. And did you yourself observe any injuries?
Yes.
And what were those injuries?
So Chartria had a cut on her hand. The sister, Shakiria, had a bruise on her forearm.
Okay. And okay, you've answered that. No further questions. Thank you.
Mr. Lynch?
I'm listening. Just a couple questions, Officer Angeles. One of the individuals that you spoke to during the course of your investigation, I believe you indicated was my client, Mr. McNabb. Is that correct?
Yes.
And isn't it true that what Mr. McNabb told you is that he was jumped by his girlfriend and her sister, Shaika?
I'm gonna object to that, Your Honor, unless the defendant intends to testify.
So I believe that it would be admissible under a statement by, it's 801, statement by a party opponent. It's you know, what my client said is admissible because it's his own statement. I don't think he has to testify for that.
And Your Honor, I will argue that it is hearsay. The counsel is wanting the officer.
Exclusion, I'm sorry. Hold on.
Counsel is wanting the officer to testify to what the defendant said or get into what the defendant said when the defendant is choosing, which is his right, not to speak.
So it's a hearsay exclusion, Judge. It's admission party opponent.
1 second. Overrule.
So you can answer the question, officer.
And your question was, if you don't mind?
That Mr. McNabb told you that he was jumped by his girlfriend and her sister, Shakira.
Yes.
Okay. He also told you that he fell on the ground in the process of being jumped by Chartria and Shakira. Isn't that correct?
Yes.
You, during the course of your investigation, you were shown a video. Isn't that correct?
Correct.
And that video that you were showed, well, what did you see on the video?
On the video, I saw Chartria with some items of Mr. McNabb, in which a physical altercation ensued then. And I could see Chartria on the ground with Mr. McNabb. But after that, the video kind of cut off, so I wasn't able to see anything further.
Okay, so you were able to, how were you able to determine that the items that they had were Mr. McNabb's?
Believe Mr. McNabb told me those were his at one point, but I can't completely recall that.
No further questions at this time.
All right. Any redirect?
No, Your Honor.
All right. May this officer be excused?
I can just have one moment. Your Honor, if I could just hold this officer, just briefly.
All right. All right. So Trooper, just if you will just hold for a moment, you can go ahead and mute and we'll call you when necessary. All right, next witness.
Your Honor, the next case, one moment. Your Honor, the state at this time we'll call Officer Covington. Is he still in the courtroom, Mr. Lynch?
Oh, yes, ma'am. Yes, sir. I mean, yes, ma'am.
No, you're fine.
So I guess you're gonna stand right here. Actually, let's not get our stuff mixed up.
And good morning, officer. Are you able to hear me?
Yes, ma'am.
Okay. May you please raise your right hand? Do you swear or affirm that testimony that you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. May you please state your first and last name, please?
Name is Officer Leon Covington.
Okay. And how are you currently employed?
I am a police officer with the Clayton County Police Department.
And on April the 11th, 2023, were you in fact employed with the Clayton County Police Department?
Yes, ma'am.
And being employed with the Clayton County Police Department, are you post-certified?
Yes, ma'am.
Does it give you the authority to issue citations?
Yes, ma'am.
And do you have arrest powers?
Yes, ma'am.
And I want to draw your attention to this incident date, April the 11th, 2023. Did you respond to 6726 Terra Boulevard, Jonesboro, Georgia?
Yes, ma'am.
And is that located here in Clayton County, Georgia?
Yes, ma'am.
And on this particular day, why were you dispatched to that incident location?
I was dispatched there in reference to a disturbance call.
Okay. And did you make contact with anyone at that location?
Yes, ma'am. I made contact with the property manager of the location.
Okay. And do you recall the property manager's name?
I believe Miss Tyra Bailey.
Okay. And after speaking with Miss Bailey, what did you do? What did you learn during your investigation?
I learned that the defendant traveled over to the leasing office in reference to his residence being burglarized. He went to the location yelling and cursing and was asked to leave by security personnel, at which point the victim stated that.
So I'm gonna object to victims' statements and on the basis of hearsay at this point.
Your Honor, I believe this witness is available. Miss Tyra Bailey is available.
Overruled.
Go ahead, officer.
I'm sorry, I can't think where I left off. Yes, so he was asked to leave by security personnel, at which point the victim advised me that the defendant was issued a criminal trespass warning from the property prior to the incident.
Okay. And did you make contact with Mr. McNabb on that day?
Yes, ma'am.
Okay. And at that point, did you make an arrest?
Yes, ma'am.
Okay. And what was the basis for your arrest?
So he was charged with criminal trespass. I verified that he was issued a criminal trespass warning through Clayton County database. Also, the defendant admitted that he was told to not come to the leasing office.
Okay. Thank you, Officer Covington. No further questions from the state at this time.
Okay, Pete, you mind staying on? Okay, we're good, right? Okay. I'm gonna ask you some questions, officer.
Okay.
Sorry, this is a little different.
Okay.
So the criminal trespass warning that you're referring to, did you see a copy of it?
Yes, sir.
And where did it indicate that he was banned from going?
From the property at 6726 Terra Boulevard.
That's the entire apartment complex?
I can't recall if it was the leasing office or was it the entire complex.
Okay. But you stated that you learned that Mr. McNabb went to the leasing office because he was upset about his apartment on that property being broken into. Isn't that what you testified to?
Yes, sir.
Okay. So from that, it would indicate that he was currently living or had an apartment at that apartment.
I'm going to object, Your Honor, to speculation.
He can answer if he knows. He would have taken his address, I presume.
Did you learn during the course of your investigation that Mr. McNabb lived at that apartment complex?
Yes, sir.
Okay. Is it common, or in your experience as a police officer, that someone can be issued a criminal trespass warning from their own apartment complex?
Yes, in the case that if they have issues with personnel, leasing, management personnel, usually management would issue them a criminal trespass warning to prevent them from going to the leasing office.
Okay. All right. No further questions at this time.
All right, any redirect?
No, Your Honor, this,
Okay, may this officer be excused?
I could just hold this officer.
All right, next witness.
Your Honor, at this time, the state will call Ms. Tyra Bailey.
All right, Ms. Bailey, may I see you, please?
Sorry, I'm trying to move my camera around so I can turn it on.
Okay, raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
I do.
All right, you can put your hand down. All right, Ms. Potter, your witness.
Yes, Your Honor, thank you. Ms. Bailey, may you please state your first and last name and then spell your first and last name, please.
Tyra Bailey, Y-R-A, last name B-A-I-L-E-Y.
And how are you currently employed, ma'am?
I'm a property manager.
And where are you a property manager at what location?
I prefer to not give my current location, as it is still in the Clayton County area. And yeah, I'm sorry, I don't know if that's allowed, but I don't want to give my actual current location.
Well, where are you you're not comfortable with providing the
Okay, let me ask this.
specific
Are you
apartment
still at the
community.
apartment? Are you still at the apartments you were at when this incident happened?
No, ma'am, but I am still at an apartment community in Clayton County.
Okay, just tell me where you were when this happened.
Oh, I was at an apartment community called Woods on Terra Boulevard.
And thank you, Your Honor. And how long were you employed with Woods on Terra?
With that company for 2 years.
For 2 years, okay. And so on this particular date, April the 11th, 2023, were you the one to call 911? And why?
Had a previous run-in with Mr. McNabb, and even prior to me being employed there, I had viewed video and been advised that he had a criminal trespass against the leasing office. My first initial contact with him, I wasn't aware of that. So my supervisor and my assistant at the time ended up showing me the video and saying he's not allowed here because he had pulled a gun on the staff prior to me coming there. So the next time he came, we did advise him that he was not allowed to be in the leasing office. It was only for the leasing office, not the entire community.
Okay. And on this particular day that you called the police, what happened?
So the apartment was essentially deemed abandoned because the power had been off, and we found that squatters kept going into the apartment, but there was no power and it was deplorable. There was raccoons and animals in there. And so the first time I had encountered Mr. McNabb, we had like locked it because the door was wide open. So I had changed the locks and gave him a key. And then the second time he came, he said, well, somebody broke in again. I immediately locked the leasing office door because like you could see the parking lot from the top where it was above the stairs. And so when I saw him pulling up, he has a very distinctive truck and it's a loudspeaker. So I locked the door and told all my staff, don't leave. But as he came up the stairs, the security guard came from around the building and told him, you know, you're not allowed to be here. But then the security guard went and unlocked the door to tell me, hey, he's saying somebody broke into his apartment. At that point, Mr. McNabb basically tried to push past the security guard and enter into the leasing office. And I'm telling the security guard, shut the door, shut the door, shut the door. And then he finally got the door closed and we locked it again. And then I called the police.
Okay. And is that when the police arrived?
Correct. When the police arrived, I went down the stairs and I did advise the officer that he had a CT from the leasing office and he was not allowed to be there. And he did talk to Mr. McNabb, and then he came back and he said, well, he's saying somebody broke into his apartment. And I said, he needs to contact the police, you know, not come to the leasing office calling me names, yelling and screaming and pushing past the security guard to try to get, well, I can't speculate, but to try to get inside.
Okay. All right. Well, thank you, Ms. Bailey. No further questions.
Mr. Lynch?
So, Ms. Bailey, you wouldn't disagree with me. I'm not talking about the leasing office, but I'm talking about as far as that apartment, that my client had a right to be in the apartment on April 11th, 2023. Right? He hadn't been
Absolutely. He had a right to be in his apartment. Absolutely.
Okay. And you don't dispute that there had been a break-in or, well, let me ask you this. It was relayed to you by the security guard that he was coming up there to attempt to address the fact that he believed his apartment had been broken into. Is that fair to say?
That is correct.
And you also testified that the security guard actually opened the door and kind of relayed that message that he was there to raise concerns about his apartment being broken into. Isn't that?
That is correct.
Okay. Now, did he enter inside the leasing office at that point?
Yes, he did. He like the security guard, when he opened the door, he was like sideways and he's like, hey, he's coming up here because he thinks somebody broke into his apartment. And Mr. McNabb came through over top of him essentially and was like, you know, yelling explicitives and y'all are going in my apartment and all of this.
Okay. And then did he leave after he made those statements?
No, he was there when the police pulled up.
Inside the leasing office?
No.
So he did leave from inside the leasing office then?
Yes. Mm-hmm.
Did he do that?
He didn't make it, he never made it all the way into the leasing office. He was just like reaching over. And so like his arm was made it in like half his head. But
So
the security guard was standing there as a barrier.
I'm sorry. So he didn't actually make it all the way inside the leasing office. He basically was trying to get through the door and he was making statements. Maybe his arm came through the threshold and he was making statements to you in regards to him being upset about what he thought was going on with his apartment. Is that fair to say?
That is correct.
Okay. No further questions.
Any redirect?
Yes, Miss Bailey, if you can recall the woods on Terra, where is the leasing office?
Leasing office, I would say, is mid the community. So when you come down a long driveway, we called it, and then you take a left and the leasing office is there in the center of the community.
So is it a standalone building or is it within apartments?
Nope, it's a standalone building.
Okay, and how far, if you can recall, where his apartment was in the leasing office?
His apartment was in the very back of the community. So the driveway, it goes all the way to the back, and literally the leasing office is like the middle point of the community. And then when you go all the way to the back, his apartment was in the very back of the community.
And is there parking spaces designated just to the leasing office?
Yes, ma'am, that is correct. When you turn into the leasing office parking lot, that's only there's no apartments up there, and you have to go upstairs to get to the leasing office. It's a
Okay.
flight of stairs up, so it's even elevated from the parking lot.
Okay, great. Thank you so much. No further questions from this witness, Your Honor.
All right, may this witness be excused? Any recross?
No, Judge.
All right, ma'am, you're free to go at this time. If you want to stay and hear the remainder of the hearing, you can just mute your device, okay? All right. All right, does the state have any additional witnesses?
State has no additional witnesses, Your Honor, for this motion 2022 CR 00704.
All right, is there a motion for the other case, or is this encompasses both?
It's for both, Your Honor.
All right, does the defense have any witnesses that they wish to present at this time, or any evidence to present?
Look, I don't believe so, Judge, but can I just ask clarification as far as both motions that are to be heard today? Has the state presented all the witnesses, or are we going to do another motion after this?
I
So,
know.
Your Honor,
First, let me ask this: are there 3 cases pending, or only 2 cases pending?
So, Your Honor, there are 5 cases pending.
Including
So I filed 2 motions to revoke bond, Your Honor, but they have the same witnesses.
Okay, that's fine.
The exact same witnesses would testify to the same information for both, because these incidents happened after he was arrested on both of these. Well,
Okay.
the battery family violence happened after the
Yeah.
2024
So I
CR.
got the April 11th, 2023, and then August 17th, 2023. And are y'all going to testify about the next case in the series, or are these the only 2 cases I'm going to hear about?
These are the only 2 cases, Your Honor, that the state is moving to revoke based on the information that's provided. We didn't file a motion to revoke bond for,
Excuse me.
let me see, 2024 CR 0, no, we did on that one. Yeah, so.
You did or did not?
We did not. On the simple assault, we filed a motion to revoke bond. In the simple battery, we filed a motion to revoke bond. The motion to revoke bond from the simple battery and terroristic threats, the case motion for the case August 17th, 2023, and also the April the 11th, 2023. Those 2
So,
cases. Yes,
what
sir.
I'm getting at is there is only one, if the case has been argued, there's only one bond revocation that I need to consider. And that's the bond that existed from the April 11th, 2023 case that was then violated by getting charges on the August 17th, 2023 case. Is that what the state is?
November 29th, 2021 case, the state filed a motion to revoke
Okay.
bond.
But I haven't heard anything about I haven't heard anything about that, or even that he
I'm
had
sorry.
case pending.
One moment, I'm just trying to get my.
Yeah, so what I'm saying is the only thing before the court is there's one violation of bond, because the bond that he had for the first case would have been the bond he violated to get the second case. Now, if there's an additional bond violation, I'm not hearing that there's a third case or a fourth case.
Okay, Your Honor. So the state filed a motion to revoke bond 2022 CR 00704. The incident happened November the 29th, 2021, Your Honor. That is the very first case that he had a bond on. Those bond conditions was on December 6th, 2021, where it was to stay away directly or indirectly from
Okay,
Shakira
but
Hutcherson.
what I'm saying is you haven't put that on the record. You filed it based on that, which would have meant that the April 11th would have been a bond revocation, would have been a bond violation, and the August 17th would have been a second bond violation.
Correct,
But
Your Honor.
I haven't heard anything on the record about this November. So you haven't given me that a bond existed or he was arrested and he had
Your
a bond.
Honor, so when the motion to revoke bond was filed, those witnesses wouldn't be here because I am bringing.
what I'm saying to you is you haven't established that that November bond existed. You haven't put anything on the record about a bond existing so that the April would have been a revocation event. You get what I'm saying? You got to first establish that he had a bond in November of whatever. You
That
haven't
is
put
correct, Your
anything.
Honor, and that's, yes, and that is part of the record that the state filed in their motions that was added to exhibit.
Okay, but so the motion and what we're hearing, you haven't put it on the hearing record is what I'm saying.
Oh, okay, I understand, Your Honor.
Okay, yeah, I get that. That's why I want to be clear, because what the transcript is what people are going to look at. They'll look at the, if there's ever appellate review, they'll look at the record, but they'll look at the transcript to see where the argument was made that there's two bond revocations. I can't just say, okay, well, I read the report, and because I got to give Mr. Lynch a chance to respond to it.
Correct, Your Honor. So the state's first pending motion from 2022 CR 00704, the court filed, I'm sorry, the court ordered on December the 6th, 2021, and it was filed on December the 6th, 2021. Your Honor, the state will ask the court to take judicial notice based on this being a part of the record. This is with the clerk's office, and it was filed by, at the time, Magistrate Court Judge George. In this case.
All right, and those conditions said what?
In those conditions, Your Honor, the defendant was charged with simple battery and also terroristic threat. Your Honor, those conditions, it stated, stay away absolutely directly or indirectly by mail, email, pager, telephone, or third party from the person, home, workplace, and immediate family members of any witnesses included but not limited to Sha'Carrier Hutcherson. And I apologize, Your Honor, if I'm pronouncing Sha'Carrier incorrectly. And then his second bond condition, the defendant must not violate any laws while on bond. That was ordered on December the 6th, 2021.
All right. That's what I was trying to get at, because for what you presented with the officers, there was only one bond violation, but that establishing first that there was a bond existing from 2021 now gives me two bond violations to consider. All right, Mr. Lynch.
Well, I would object to the court taking judicial notice, but I do see that as Exhibit A to the motion, they did attach the bond that we're talking about here. I would point out, though, that if the court considers that being introduced, that this document is not signed by the defendant, it's not dated. So I guess, is this my time to argue, Judge?
No, this was establishing that I'm clear on what the record is.
Okay.
It has been admitted as an exhibit to the motion. I'm fine with that. I just wanted to get it on the record here during the hearing that there was another bond existing. Now, it's because it's part of the record, I don't have a problem with acknowledging it and taking judicial notice. But the reason I wanted to also read the actual bond conditions was because we have run into that situation where I don't know what magistrate was doing, but there was bond conditions that did not also say that you can't have additional criminal charges filed. So I wanted to make sure that we were clear on everything that it was consistent with what I understand the bond conditions to be. All right, so now the state doesn't have any other witnesses to bring. The defense doesn't have any other witnesses, so I will hear argument.
Yes, Your Honor. Your Honor, so the state filed a motion to revoke bond in case 2022 CR 00704. As the state requested, Your Honor, the state has requested that this court take judicial notice of the defendant's bond conditions. Those bond conditions, which is part of Exhibit A on the court's motion to revoke bond. It was ordered on December the 6th, 2021 by the Honorable Judge Sonia George. as the state, in the order, it states she'll stay away absolutely directly or indirectly by mail, email, pager, telephone, third party from the person, home, workplace, and immediate family members of any witness, including but not limited to Shakuria Hutcherson. Shayquria Hutcherson, Hutchison. And lastly, another condition was the defendant must not violate any laws while on bond. Your Honor, you had an opportunity to hear two separate cases in which the defendant did display some type of violent nature. In one of his cases, Your Honor, you heard from Trooper Angeles, who indicated that he did arrive on scene and spoke to a Shantaria Hutcherson and a Shakuria Hutcherson. Your Honor, one being the sister and one being the defendant's child's or defendant's child's mother. Also, you've heard from the officer that there were injuries that he observed himself. He indicated that one of the witnesses had I just want to make sure I have that correctly. He indicated that one of the witnesses had a cut to her hand and another witness had a bruise to her forearm. He did indicate that he spoke with the defendant, Mr. McNabb, which is a violation of his bond conditions. One, him being there and in contact with Shakuria Hutcherson. And then two, Your Honor, he picked up new charges for battery, family violence, and cruelty to children. As the court heard, there were minor children there, a 7-year-old and a 9-year-old child. Furthermore, Your Honor, there was an instance where there was another case where Mr.
If we're talking about a case that hasn't been introduced, are we getting into a case that we didn't deal with on the record here?
There were two cases we spoke about.
Sorry.
Okay.
Go ahead. I didn't mean.
And not only, Your Honor, did he pick up this case on August the 17th, 2023, that was the first case that the court did hear. However, he continued to pick up a case even before that, September the 20th, 2022. In this case, Your Honor, you heard from the actual victim in this case, Miss Bailey, who was at the time the property manager. She testified that to her knowledge, Mr. McNabb received a criminal trespassing warning from the actual leasing office because he had an outstanding case where he is her understanding, her knowledge that he pulled out a gun and threatened someone at the leasing office. So therefore, he was told that he could not come back. She did testify that the leasing office is not the same location as his apartment. His apartment is in the back. The leasing office is standalone, and that is another case, Your Honor. So while out on bond from 2021, the defendant has picked up two other cases, which is violent in nature. One, a battery, family violence, and cruelty to children in the 3rd degree, and also a criminal trespass in which the victim did state that he was criminally trespassed from that leasing office where he began to shout and scream profanity. And so for that, Your Honor, the state will ask this court to revoke the defendant's bond.
All right, Mr. Lynch.
So, Judge, I'm going to get into the factual allegations and discuss the two cases that the state has alleged to be violations of his bond. But first, I do want to speak a little bit about Mr. McNabb. So Mr. McNabb is he's 33 years old. He does have 4 children with Shatria Hutchinson, I believe. He is currently working. He works at a warehouse where he's worked for the past, it's been over a year. He does order fulfillment. Judge, I would also point out that since the August 2023 incident, he has had no arrests. There have been no further allegations of him violating any bonds. So I point that out first, Judge, to kind of get back into the allegations as far as the battery family violence case. So I believe the officer testified that this is the location where he was living with his the children of his mother, Shartria Hutchinson. He didn't have a previous case with Shartria Hutchinson. I understand that there was a previous case with Shakia Hutchinson, her sister, but he's at the residence of his baby's mother with his children at the time. And I
But
think
do
that
you understand that if Shakia was named on that's why I asked her to read into the record, the bond conditions. If Shakia was named, then a close family member of hers would be her sister, and he would have had to stay away from her too, unless he got a modification of bond.
And I understand that, Judge. Hold on. However, Your Honor, and I understand the point that you're making. However, there was no evidence about who came to the location first, whether he was there and the sister showed up. So the court doesn't have that evidence that he, intentionally placed himself in a position with Shakia Hutchinson, who he had actually been given bond conditions to stay away from. Additionally, Judge, that Exhibit A with the bond conditions listed, I would note that it is not signed or dated. So there
You just glossed right over what I said. You know that, right?
No, I didn't mean to gloss over it, Judge. I thought
Shakia is the person on the December 6, 2021 bond. Is that correct?
Correct.
Then Lord, this is difficult. Then Shatria would have been her close family member that he's not to have contact with. If he goes back and lives with Shatria, I don't care if that is his baby mama. She's a sister of the woman who has a bond condition.
Well, Judge, and I understand that point. However, again, the bond conditions that were allegedly, presented to him, there hasn't been evidence that he actually was put on notice of that because there's no signature there, Judge. And, that is something that I feel like would need to be spelled out explicitly, because whether or not it has to be, it certainly should be, because Mr. McNabb is a provider for his children. He does work. And, I would argue that there needs to be very definite, concrete notice if he is going to be in a position where he's not allowed to have contact with the mother of his children, because
other than actually write it down. Because if you've never been to a first appearance hearing, we're talking about sometimes up to 20 and 30 people in the room. The judge is going person by person. We're not taking a deep dive, but on the paperwork, it says exactly what it says, that you're not to have contact with the family members of these individuals.
Well, I understand that, Judge, but I don't know if the client can anticipate that would apply to the mother of his children.
Okay, go ahead.
Right. Additionally, Judge, I'm sorry, I lost my train of thought there. Mr. McNabb is certainly presumed innocent on that case, and I don't think there's evidence that he intentionally violated that bond, Judge. And even, Judge, even if you consider that a violation just based on him being around the mother of his children, Judge, I would, setting the criminal trespass aside for Judge, I would ask the court to consider alternatives to revoking his bond, considering it is understandable that a man who is taking care of 4 children with a woman, and that they're actively raising the children together and cooperating, it's understandable that if it wasn't explicitly stated you cannot have contact with the mother of your children, that he wouldn't just, and I understand it's written there on the paper, Judge, but I'm also asking you to consider the realities of how people live and family dynamics, Judge. It's a great surprise to many defendants that these orders that they're given would apply not just to the alleged victim, but also to, you know, their family members and people who they have to deal with on a regular basis in the rearing and the support for children, Judge. And I would also ask you to consider the fact that Mr. McNabb is currently employed. He has been employed for over a year at the same facility, Judge. He hasn't got any additional charges since 2023. You asked him via Zoom to come in here and appear before the court. He has done this. He's not running away from these cases, Judge. He only asks that you allow him to remain out on bond and be able to face these cases individually. The other allegation of bond violation was the criminal trespass, Judge. You know, this is at the apartment complex where he lived. He was raising a concern with his living space. And I understand that you could call it a technical violation of him going into the leasing office, but I don't know, you know, he has got to try to address the fact that his apartment has been broken into in some manner. And that's all the evidence supported that that's what he was doing. He didn't make it all the way into the leasing office. Ms. Ponder's characterized his behavior as violent, but he didn't attack anyone. He didn't, you know, it seems that he stopped at the doorway and didn't, you know, there's no indication that he was attempting to initiate physical contact. And again, that's, you know, something that would not necessarily, he may not have thought about when he's returning to his place of residence, his apartment, and trying to address concerns with the fact that his apartment had apparently been broken into, or in that, and even the leasing officer testified that his locks were changed, Judge. So, you know, he obviously needs to get access to his apartment and needs to have these issues concerned. I don't know if there was ever any sort of alternative mechanism for him to address these concerns with the leasing office that, you know, did involve him going into the leasing office, Judge. And again, Judge, you know, I understand magistrate court, there's a lot of cases, but that exhibit is not signed or dated. You know, no additional evidence was presented as other than that paper that was filed with no signature. There's no additional evidence of how that notice was relayed to him, whether he got a copy of that, whether that was presented to him. That was not presented, Judge. But my main argument, Judge, I understand that there's several cases, Judge, and ultimately these cases are going to be resolved. And if he's convicted on one or more of them, Your Honor, obviously will be in a position to evaluate all the facts and all the considerations and issue a sentence. But I would ask that instead of putting him in jail now, which would destroy his ability to support his family, to keep his job, I would ask that you instead admonish him about what bond conditions do exist, if Your Honor wishes to impose additional bond conditions, but allow him to remain free unless there are additional bond conditions so that he can have his day in court and present his defense, Judge.
And Your Honor, may I?
Yes, ma'am.
Your Honor, so regarding the bond modification, I'm sorry, the order for bond, as the court is aware at that time, it was during COVID or during the pandemic in which they were not giving utensils in order to write, where magistrate court, Your Honor, was speaking to them verbally, and at that point they will understand. Your Honor, even if the court saying, hey, there was no signature, or if counsel is arguing that there is still IOLA factors that this court can take in consideration that doesn't require even bond conditions. And four of those factors, Your Honor, is whether one of those is whether he's a threat to witnesses or he's a risk of committing another crime. And I submit to Your Honor, Mr. McNabb has been out in custody since 2021. And every year since except this year or last year, he has not picked up a new case. And Your Honor, it's not just traffic offenses, but these are cases where there are victims associated with these cases. Even if, as counsel did not want to go into detail and harping on the fact that he was around his sister, his child's mother, or he was around the sister of his child's mother, he failed to mention that the officers indicate that there were some bruisings to both individuals, but not that his bond conditions was not to violate or pick up any new offenses while out on bond. Not to say that he is found guilty for any of these, Your Honor, but more so him just picking up those charges. As you've heard from Ms. Bailey, Your Honor, as I will indicate it, she stated that he was trespassed from the leasing office because the prior case in which the defendant had a firearm and made threatening statements. So not only did she fear to the extent where she had to lock her doors of a business, where she is a manager of, she is here today, she testified, and she's not even working at that location. And she still appeared, Your Honor, before this court to tell the court exactly what happened on that day. I believe when counsel makes reference to the fact that he is a father and he's a provider, he should have thought about it, that, Your Honor, before he picked up new cases or before he picked up those violent offenses in front of his children, that 7-year-old and 9-year-old child that was present at the time that he picked up those cases against their auntie. Your Honor, so at this time, I will ask this court to revoke the defendant's bond.
Judge, the state indicated that the IOLA factors include, threat or risk of committing additional crimes, but I believe it's risk of committing felonies, additional felonies, Judge. But I understand the concern. Again, Judge, I would just fall back on our request to the court, what we've argued as far as
okay. Okay. The issue that I have with this is that, well, first, I wish that this had been brought to my attention with respect to a bond revocation much earlier, because definitely time plays a factor in all of these things. But the thing is, I don't know how you back to back, like, you got to be clueless to not either read your bond conditions. I know I've been a magistrate, so I know they're telling you what your bond conditions are. You get a copy of your bond conditions at the jail. You can get a copy when you leave by going to the clerk's office. You know you have bond conditions. So it's incumbent upon you to know what they are. What your argument rests on is, I'm supposed to accept the fact that he was too dumb to go figure out what his bond conditions meant. And then he continues, he got either an anger issue, something's going on. I mean, because he seems to make contact with the police way more often than a lot of other people. And while I do want the man to be able to support his children, I don't have any evidence that he actually is supporting his children, other than what you said. When you have a violent event that occurs in front of children, I don't understand, like, he's not going to be father of the year by any means.
I was young.
And the fact that, you get trespassed from the leasing office at your apartment, even if his apartment was burglarized, Mr. Lynch, that's the police respond to that. What did he think the leasing office was going to do? Other than, hey, my apartment got burglarized, as they happened before. But I don't know that Mr. This is really problematic on several levels. It's problematic from the standpoint of the state, because he's got 5 cases that I know of, and the 3 y'all arguing about, the the bond conditions for the first one and the two that came after that. I'm just really just getting to know about them, which I get it. And then he's got a criminal trespass from the place where he lives. I just don't understand. On both sides, there are issues. The only thing that makes me not want to violate his bond is that he's actually working and has a job. But I don't have any indication from anybody that he's actually taking care of these kids. I don't have any indication that you don't fight in front of your children if you actually taking care of your kids.
Judge, and I understand that. I mean, and I know I can't.
I don't know what other admonishment you want me to give him, Mr. Lynch. I give admonishments every time I talk to people. I know the judges in magistrate court give admonishments. They tell you what the bond conditions mean. Unless it's changed drastically, they even tell you what the possible repercussions are of violating your bond conditions. If you violate your bond condition, you could get your bond revoked. You could come back to jail and stay in jail until such time as you resolve all of your cases. And so I don't know like how much more we got to tell Mr. McNabb. There's somebody who said if you want to hide something from folk, put it in a book or put it on paper, and they're not gonna read it. And I feel that way about bond conditions. If there's nothing more important to how you conduct your life, it's bond conditions. Read it, understand it. If you don't understand it, ask questions. But people get locked up and they don't ever think about, well, I got bond conditions. They don't think about anything that means, and it's written out. And so I don't know that we need to keep using dumb as an excuse.
And, Judge, I wasn't certainly not meaning to imply that Mr. McNabb is dumb. I don't think that is the case.
Well, not willing to read his bond conditions and get an understanding of what they mean.
Your Honor, I think that's state's position is that's an excuse. After one case, that's fine, Your Honor, but he has multiple cases before the court. And as soon as I learned about this, Your Honor, I myself filed a motion to revoke bond because of how egregious in nature, in my opinion, it is. But I don't think that the court should just slap Mr. McNabb hand on the wrist because the state didn't catch it in time, or the fact that he has a job when he knew he had a job then. And so I can understand one case give grace, but he has multiple cases. So it's as if he's just turning his nose up to the system, hoping that, oh, I have kids and I have a job. Please keep me out.
Yeah. All right. At this time, Mr. McNabb will be taken into custody. Bond will be revoked.
Judge, could I ask you to reconsider? Mr. McNabb certainly is presenting himself to you. I've argued he hasn't caught additional cases, Judge, and he's willing to comply with any additional.
I mean, how many more would he need, Mr. Lynch? He got 5. I'm considering 3 in front of me. But I mean, really? Yeah. At this time, Mr. McNabb will be in jail until such time as his cases are resolved. Get me an order, Ms. Ponder.
I will, Your Honor.
All right. So.
Hey, Your Honor, may I just have a brief moment? I'm just trying to see exactly what other witnesses we have so I can
Okay.
update.
Yeah, and if you could release those the trooper and the officer so they can get back since we've done with this.
Yes, Your Honor, I released them when we did arguments.
Okay.
And then Miss Bailey just logged off as well.
All right, thank you.
Your Honor, if I can just have one moment.
All right. All right, we ready? We still have Archie, Bowie, Green, Lassiter, Lockwood, Myers. Shealy is a motion to revoke. Trammell, Whitaker. Those are the remaining cases.
Okay.
Who's in the booth? Who's ready?
One person in the booth is, everybody's ready, but whichever one you want to go.
Bowie is a motion for bond. Is that the gentleman I saw the last time?
Yes, Judge, a gentleman where there was no bond issued.
Okay.
Um,
Did y'all consent? Did y'all come up with anything?
we had spoken on it. We never got a chance to kind of finish that conversation, I don't think.
Do you have your phone, Mr. Lynch? I can send you a message.
Yeah.
Then we can do another case while we're.
Yeah, we're ready on most of the pleas.
I'm ready on whatever.
Lassiter, bring up Lassiter.
That's true.
All right. This is Whitaker.
I'm sorry. That's correct. This is Lassiter, Your Honor.
Lassiter. All right. Mr. Lassiter, raise your right hand for me. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am, I do.
All right, you can put your hand down, Mr. Lassiter. You're before the court on 2 cases. Your attorney is with you, Mr. Taz Taylor, with the law firm of Lister, Holt, and Dennis. All right, Mr. Taylor has indicated that you're entering a plea. Hold on a second. All right, so you're before the court, Michael Sean Lassiter, 2025 CR 03319 for simple assault. Your attorney has indicated you're entering a plea of guilty. And for case 2025 CR 03369, failure to yield the right of way, you're entering a plea of nolo. By entering the plea of nolo and the plea of guilty, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself or present any testimony or evidence to against yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Did you understand your rights?
Yes, sir. Yes, sir. Yes,
All
ma'am.
right. All right. Factual basis and recommendation, please. Let's start with case 33, the case ending in 03319.
Yes, Your Honor. On April the 29th, 2024, officers responded to a reported disturbance at 6698 Homestead Road, located here in Clayton County, Georgia. Rex, Georgia, and give the court the whole address, excuse me, 6698 Homestead Road, Rex, Georgia, 30273, here in Clayton County, Georgia. When officers arrived on scene, they made contact with a Dawn Nelson, D-A-W-N Nelson, N-E-L-S-O-N. Officers learned that the victim is the sister of the defendant, Mr. Lester. Officers learned that there was a verbal altercation in which the defendant threw a can at her in the midst of an argument, striking the wall beside her. Those are the facts of the case, Your Honor. The state's recommendation is 12 months to serve, 90 days. Balance suspended, no contact with the victim, Dawn Nelson. Your Honor, I would just like to submit to the court, Ms. Nelton wanted us to communicate with the court. She wants absolutely no contact with the defendant.
All right. Okay, and go ahead with the second
In the
case.
second case, Your Honor, 2025 CR 03369, the failure to yield to the right of way. Just trying to get the dates. One moment, Your Honor. On April the 25th, 2024, officers responded to a motor vehicle accident. Officers learned during the course of their investigation as driver 2, which was later identified as the victim, Augustine, Agustin, Yanez Rivera, Yanezrivera. Officers learned that the defendant, Mr. Lasser, did pull out of a business, striking vehicle 2. Those are the facts of the case. The state's recommendation is a $100 fine, suspended. No restitution is requested.
All right. So anything, Mr. Taylor?
Your Honor, we just ask that the court give Mr. Laster credit since his date of intake into the Clayton County Jail on case 03319 and accept the state's recommendation as stated on case 03369.
All right. So, Mr. Lassiter, I'm going to accept your plea of guilty on the case ending in 03319. I'll sentence you to 12 months to serve, 90 days. Balance will be credit for time served. Balance will be suspended as long as you have absolutely no contact with Dawn Nelson. And by that, I mean, if you were to violate my sentence, by having contact with Dawn Nelson of any kind, social media, phone, text, going to the house, anything, then you could be rearrested. You could serve the remainder of your sentence. And in jail, you could also be charged with additional misdemeanors or the felony of aggravated stalking, which is punishable by up to 12 months in jail. I'm sorry, up to 10 years in jail, a $10,000 fine, or both. Do you understand?
Yes, ma'am.
All right. Count 2. I'm sorry, the second case ending in 03369. That's a fine in the amount of $100. It'll be suspended. And at this time, sir, you'll be free to go.
Those are other charges.
All right.
Pending.
All right. I'll be right back.
They dropped it. They say the count 3. They only went forward on this case. Only went forward with count 3. Okay. Yes, sir.
All right, who's next?
Judge, sorry, the deputy stepped out, so I'm not able to get someone out here, but I think we can probably do Green next.
Okay. All right, well, I'll be right back.
Mr. Lynch, I sent you a text regarding Mr. Bowie's case. And so,
I'm sorry, I didn't respond.
no, you're fine. I just didn't know if you received it, just so we can communicate that way if you have it.
I did. I think we'll just have to go forward with the.
Okay. No problem.
All right, this is Mr. Green.
Yes, Your Honor.
Mr. Green, raise your right hand for me.
Yeah.
You solemnly swear or affirm any testimony you give in this matter will be true.
Yes.
You can put your hand down. You're before the court on State of Georgia versus Dontavius Marcel Green, 2025 CR 03504. Criminal trespass. You're represented by Attorney Owen Lynch with the law firm of Lister Hope Dennis. Mr. Lynch, what is your client plea to the offense before the court?
Nolo, Your Honor.
All right. By entering a plea of nolo, you give up the right to have a trial by jury or a judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence of against yourself. And if you're not a United States citizen, a plea of guilty or no contest could never could negatively implicate your immigration status. Did you understand all of these things?
Yes, yes, I do, Your Honor.
All right, thank you. Facts and factual basis recommendation, please.
Yes, Your Honor. On March the 7th, 2025, officers responded to 4183 Thuman Road, Forest Park, Georgia 30297 in reference to a disturbance. When officers arrived on scene, they made contact with the store clerk who advised them that an individual later identified as the defendant was criminally trespassed on March the 5th, 2025, and now he was back on property. Officers did make contact with Mr. Green, who stated that he just wanted to buy him a cigarette. Those are the facts of the case, Your Honor. The state's recommendation is 12 months to serve, 39 days credit for time served, balance suspended, on the condition that he does not return to that location. 4183 Thurman Road, THUMAN Road, Forest Park, Georgia 30297, the business of Shell gas station.
All right, Mr. Lynch.
Your Honor, I would ask that the court accept that as negotiated. I have explained to him that he was not to return to that gas station. You understand?
All right, Mr. Green, don't go back to the gas station. You've been criminally trespassed and you got a criminal trespass violation charge. So please don't go back there. They do not want you at that location of 4183 Thurman Road, Forest Park, Clayton County, Georgia. Okay. I'm going to sentence you in exchange for your NOLO plea, 12 months to serve, 39 days credit for time served. Balance will be suspended as long as you do not go there and do not have any violations of the laws of the state of Georgia. You understand?
Yes, ma'am.
All right, you can go back to the sheriff's office.
Can you bring Mr. Lockwood?
I appreciate it. Yeah.
Hi, everyone. Good. How you doing? Stand right next to me if you don't mind.
Who's this, Mr. Lynch?
Judge, this is Mr. Lockwood. Theodore Lockwood.
Mr. Lockwood, you're before the, I'm sorry. Good afternoon, Mr. Lockwood. Raise your right hand for me. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, yeah. Yes, yeah.
All right, you can put your hand down. You're before the court on State of Georgia versus Theodore Bartley Lockwood, 2025 CR 03389 for criminal trespass and obstruction of an officer. What does your client plead to the offenses before the court?
Guilty, Your Honor.
By internal plea of guilty to counts 1 and 2, sir, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to present evidence and testimony on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes, ma'am.
All right, factual basis recommendation, please.
I can.
I'm sorry, Your Honor, who was this for?
Mr. Lockwood.
Yes, sure. Your Honor, on March 21st, 2025, officers responded to the MARTA train station located at the Atlanta airport. Officers were patrolling the platform when they conducted a welfare check. Officers did observe that Mr. Lockwood was asleep on the train. However, he did have a MARTA suspension, which was effective earlier that day, which was March 27, 2025, in which he was told not to be present. Those are the facts of the case, Your Honor. The state's recommendation for count 1 is 12 months to serve, 26 days credit for time served. Balance suspended on the condition he does not return. Counts 2 is a $300 fine suspended.
All right. So, Mr. Lockwood, I'm going to accept your plea of guilty to counts 1 and 2. On count 1, I'll sentence you to 12 months to serve 26 days, credit for time served. Balance will be suspended as long as you do not go back to any MARTA location. And on count 2, it's a $300 fine, which will be suspended, which will run concurrent with count 1.
Thank you, ma'am.
All right. Thank you, sir.
Yes, ma'am. One other thing, ma'am, when I came to jail, I had just came in from Memphis with my luggage. They took my luggage and they are holding it at my at one of the locations. I'm not really sure what location.
Okay.
Am I able to still go get my luggage?
Yeah, Ms. Wright, if you will put that he will have one opportunity to, you'll contact MARTA by phone first to locate where your luggage is, and you'll have one opportunity to go back to request your luggage and any personal items.
Okay, thank you, ma'am.
All right, take care.
All right.
All right, who's next?
All right. Take care of that.
Appreciate it. We can do Whitaker. Have we already done all your food? Getting through most of mine.
And Your Honor, have we done the probation matter?
No.
Thank you.
Mr. Taylor was asking that it be held for, there's some information that we want to hold it to the last one.
Okay, no problem.
This is Mr. Whitaker.
Yes, Judge, Jerome Dexter Whitaker Jr.
All right, raise your right hand for me, sir. You solemnly swear or affirm any testimony you give in this matter will be true.
Yes, ma'am.
All right, you can put your hand down. You're before the court on 2025 CR 03510 for Jerome Dexter Whitaker Jr. for theft by shoplifting and criminal trespass. What does your client plead to the offenses before the court, sir?
Guilty.
By entering a plea of guilty to counts 1 and 2, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you're not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things?
Yes, ma'am.
All right, factual basis and recommendation, please.
Yes, Your Honor. On March 4th, 2025, officers were dispatched to Heritage Bookstore at 6234 Spine Road, which is the location of the airport. Officers learned during the course of their investigation, after speaking with an attendant who advised that the defendant attempted to make a purchase, but was incapable due to his credit card. After being unable to make the purchase, the defendant did walk out the store with a white hoodie in the amount of $34.87. Those are the facts of the case, Your Honor. The state's recommendation is 12 months to serve. 40 days credit for time served, balance probated for him to enroll and complete an anti-shoplifting class, which is a theft prevention course, 50 hours of community service, and do not return to that location. For count 2 is 12 months to run consecutive. Do not return to that location.
And Ms. Ponder, I thought that we had discussed that running concurrent. I know in addition.
Concurrent. I'm sorry, if I said consecutive, it is concurrent. Yes.
All right, go ahead.
Judge, I would ask that you accept that. I don't know whether the state would object to it terminating if he's able to get everything completed. From speaking to Mr. Whitaker, he is currently homeless, although he has had a job recently, and he indicates he has the ability to get a job, or he has a job that is somewhat lined up.
Yeah.
And so, I had initially thought about trying to avoid probation on this case because of his status as being homeless, but I had discussed reporting with him, and he does indicate he would be able to do that. I would just ask that Your Honor consider either early termination if he gets everything completed, or consider waiving the probation fees in this case.
I'll waive the probation fees, and if he's able to get it done early, then we can discuss that, and I may consider that also.
Thank you, Judge.
All right. So, Mr. Whitaker, get done what you need to get done, sir, and so that you can be done with this. It's 12 months to serve, 40 days credit for time served. Balance will be probated for you to take a theft prevention class and do 50 hours of community service, and you're not to go back to that location. Do you understand?
Yes, ma'am. And will there be is there an address to take theft prevention course?
Probation's gonna give you all of that information, okay?
Okay.
All right. Take care, sir.
All right. And will I get out today, Judge?
Yeah, that is my understanding. Yes, sir.
All right. Thank you, ma'am.
All right. Take care of yourself, Mr. Whitaker.
You too.
All right. Who's next?
We
Yes,
have a
ma'am.
breakout room with courtroom and the judge.
Okay.
Nobody's in the courtroom. I don't know if.
Well, we're recording though.
Oh, right. Oh, that's right. Sorry.
So Ms. Ponder and the courtroom will be breakout room number 1, and I'll enter breakout room number 1.
Thank you, Your Honor.
You're welcome. Okay, who's next? Oh, the courtroom's coming back.
I think I've done all my pleas. Who should we call out next? Trammell. Yeah.
You pronounce it Trammell or Trammell?
Trammell.
You just Trammell. You think might be.
Mr. Trammell,
Yes.
raise your right hand for me, sir.
Say it again.
Raise your right hand. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes.
All right, you can put your hand down. Mr. DeMarco Trammell, 2025 CR 03517 for criminal trespass, count 1, obstruction of an officer, count 2, and public transit violation, count 3. What is your client? Oh, you're entering a plea of no load to all 3 counts. Is that correct, Mr. Taylor?
That's correct, Your Honor.
All right. Mr. Trammell, you were here not too long ago, if I remember correctly.
Yes.
All right. By entering a plea of no load to counts 1, 2, and 3, you give up the right to have a trial by jury or judge. You give up the right to have the state prove your guilt beyond a reasonable doubt. You give up the right to have the presumption of innocence in your favor. You give up the right to confront witnesses, subpoena witnesses, present testimony and evidence on your behalf, to not incriminate yourself. And if you are not a United States citizen, a plea of guilty or no contest could negatively impact your immigration status. Do you understand all of these things, sir?
Yes.
All right. Factual basis recommendation, please.
Yes, Your Honor. On March 31st, 2025, officers were conducting a welfare check on train number 309. This location is at the airport. Officers made contact with the defendant, Mr. Trammell. Officers learned that Mr. Trammell did have an active criminal trespass. Those are the facts of the case, Your Honor. The state's recommendation for count 1 is 12 months to serve, 17 days credit for time served, balance suspended, do not return. The defendant does have a permanent ban from MARTA station as of April the 4th, 2025. Count 2 is a $300 fine. Count 2 is a $300 fine. Count 3 would be no pros.
All right. So $300 fine. I think he has housing issues.
And Your Honor, I was just looking at that. That recommendation was communicated or negotiated with another attorney. The state will suspend that. Suspend
All
that.
right. Thank you.
You're
All right.
Under.
Mr. Taylor, anything on behalf of Mr. Trammell? I think he just turned 18.
That's correct, Your Honor. He just turned 18, and you're also correct about his housing situation. He's currently homeless, so would have difficulty paying any fines or.
Let's see if we can get Mr. Trammell some information about Covenant House. I know Covenant House Atlanta.
Yes, Your Honor. I'll look into that and see if I can provide that information to him.
Hold on a second.
Deputy, if you'll just hold him for a few minutes so I can look up.
All right, here it is. So Covenant House Atlanta, Mr. Trammell, it's an agency. It's been around here at least for 25 years. And what they do is they help with people who are young and who are homeless. So they provide services, they help with getting you settled, help you get back on your feet. So let me go ahead and give you that information. The shelter, it says if you need shelter, I have a phone number. Are you ready for that, Mr. Taylor?
I am, Your Honor.
404-713-0954. That's the shelter number. Then they have a main phone number of 404-589-0163. And this is Covenant House of Georgia. Now they're in it, city of Atlanta, but you may be able to get them, like make an agreement with them about, maybe they'll pick him up or something like that, or directing him or how best to get there.
Thank you, Your Honor.
All right, thank you. Mr. Trammell, Covenant House is well known for their ability to help kind of teenagers get back on their feet, because not everybody comes from the same type of home where they have, support. A lot of things happen. Parents can, be ill, they can pass away, and then you end up with not a lot of support. But Covenant House is one of those places where they've dealt with this for years, and they are very caring and very able when it comes to help put you on the right track. Okay. All right. Thank you, sir. All right, you can go back with the sheriff's office. Thank you, Ms. Ponder.
Thank you. Thank you.
All right. Well, whoever is next.
That would be Mr. Myers, Corey Myers. Your Honor, I believe we're bringing out Mr. Myers next.
Okay.
And Mr. Taylor, would that be for both cases or just one case?
I didn't get the information on the other case. You may have.
Sorry, I thought
Did you text or email me?
Well, no, I had made the announcement that I had for his other case. Y'all had discovery on 3/17/2024 for the simple battery.
Okay. I just don't have access to some of the stuff right now. If you want to send to the chat window, I can relay to him that message to see if he wants to resolve the second case as well.
Okay. Okay, one moment.
The prosecutor, Deputy Chief Ponder, is going to send me recommendation to resolve both cases. And I'll let you know what that is and you choose to accept it or not. Right now, this is your case. And it's 180 days. No problem. You want to talk to the judge. That's just for this case.
And Mr. Taylor, is this Mr. Myers?
Is my mom on here?
I don't know.
It says civilians, and it's my mom.
Yeah, okay. Then it's your mom. Yeah.
She there?
Yes. It appears that I want to say the alleged victim, Mr. Myers' case.
Okay, so
Online. Just
Henderson, that's on the case for the criminal trespass. Is that correct?
that's correct.
Okay, and then he has another case. Did you want to talk about that case with him, or are you just going to go forward on the criminal trespass?
Well, did you have a recommendation to resolve both of those?
It'll be the same. It'll run concurrent.
Run concurrent 180 days, and that would also close out the. Give me just a moment.
Okay, no problem. Hey, Ron, that order was sent for Mr. McNabb cases.
Okay,
Thank you.
we ready to go forward on Mr. Myers?
I'm ready, Ron. I'm gonna, court is ready.
All right,
Your Honor,
yes,
Mr. Myers has wishes to address the court. He is concerned, and I've attempted to explain this to him. He has felony charges, and I've told him that this court does not have jurisdiction to address any of those charges. And I, as his attorney, I only represent him on the misdemeanor cases, and there's nothing I can do to make those Superior Court procedural issues go any faster. So I think he needs to hear that from somebody else.
I don't know who can make it go faster or give me anything, like, come on, because if I accept that, that's what I was saying, if I
As
say
a judge,
not.
you have a question, you can ask her.
I
I
was gonna
told you to have the opportunity.
Excuse me, Your Honor. I was saying, I'm not guilty for these charges, but it's going to get me out of jail faster if I plead no contest, but I wanted to plead not guilty, but they said that'll be like 2 extra months until I even get back into court. So in 2 months, I don't know if I'll have seen a judge for the charges that I'm in here for right now, because I haven't seen a judge for the felonies that I'm in here for, and it's been 6 months. I don't have a bond. I haven't been to a bond hearing in 6 months. It's just like they just forgot about the case.
okay, do we know which judge he is on for his felonies?
No, Your Honor, I can check that.
Ms.
I'm
Wright,
not
can
sure
you
if it's
check
been,
that for me? Can somebody check to see which judge he's assigned to for the felonies?
And Your Honor, I can check as well to see if I can get any information I can provide.
Mr. Myers, I don't do felonies, but I can check and I can send an email to let the judge know that you haven't been seen for a bond hearing and that you haven't been seen on your case upstairs, okay?
Thank you. That'd be awesome. Thank you.
All right, I will do that. That's no problem. As soon as they tell me which judge, I'll send an email.
Okay, I would have pled. I wanted to plead not guilty, but then I was like, I don't know when I'm going to ever go to court for the next charges for the felony. So I don't know if I'll be sitting here and still waiting for the felony that I'm fighting right now, the felony case.
Now, that's between you and your attorney. If you feel like you plead not guilty, I'm sure our case will come up quicker than the felony.
It's going to take a long time for me to come back.
Okay, listen to me, Mr. Myers. Our case, the misdemeanor, will come up quicker than the felony. That's almost a given. I can't, there's nothing nothing's going to really change that. We will be done quicker than the felony. The problem is you will still be in jail because of the felony. Now, like I said, what I'm willing to do is send a message to the judge in the DA's office and say, hey, this gentleman says he hasn't been seen, public defender, because you'll have one of those upstairs too.
Your Honor, I do
No.
see that he was charged on November the 19th, 2024 for ag assault, armed robbery,
Has
And
been assigned to a judge?
I see that,
I don't practice in the court. I don't know.
see that he had prelims and it was an order prepared December the 18th, 2024. The current judge I see, it appears to be a magistrate court judge. I can't see anything
So it
else.
hasn't even, so there was a prelim order, but it hasn't come up from magistrate yet?
It said it was bound over to Superior Court on December the 18th, 2024.
Okay.
And yeah,
Give me
it
a
was
case.
bound over.
I see a Superior Court case with Judge Mason
Judge
for ag
Mason.
assault.
That's the one.
It's an armed robbery or two that I've been charged with. And
That's also Judge Mason, armed robbery.
Okay, so yeah, but Judge Mason has your case. What I will do, because I'll let him know that you had a prelim in December. Your case has been bound over to his court and that you were asking about when you might see, when you might get on a calendar, okay?
Yes.
All right, so that's all I can do, because he's in
another
a separate court.
Do you know how long that would usually take for me to go to court for a felony?
I do not, because I don't do felonies. I've never, I don't do that stuff upstairs, okay? So I can't tell you what judges have what's already pending. I don't know, okay? But what I will do is make sure that you are on Judge Mason's radar, okay?
Yes, ma'am.
All right, thank you.
So on
All right.
today's case, do you wish
So
to-
did you still wish to go forward with the no-go plea here?
Can I get can me and him talk for like 2 more minutes, maybe 3?
Yeah, go ahead.
Hold on.
I had a thing in mind, but it's like I'm keeping
Your Honor, may I just step away briefly?
Yeah, are we gonna be ready on Mr. Myers soon? I'm sending the email to the other judge right now and to the public defender and to the DA's office, so.
Your
But
Honor,
yeah, that's fine.
it should be quick. I just need to step away and I'll come right back.
Yes, ma'am.
Thank you.
Your Honor, I have a request for Mr. Myers when you're ready to proceed.
I'm ready.
What did my mama say? Like, she said, say her name right there.
I
Did she not talk? Because she's the
No.
victim. She's the victim.
This is not.
This is not a trial.
My
She
mama
doesn't-
said she gonna drop the charge. She said she don't want this to be happening. My mom said,
Well, your mom called the police, and at this point,
She
it's not
changed
up
her-
to her.
"Right."
Just. Your Honor, on behalf of Mr. Myers, we're requesting that this case be continued for 2 weeks so we can
Okay.
possibly get some identification on what's happening with this felony case.
Done deal. Continue for 2 weeks.
Thank you. Thank you, Your Honor.
Great people you are.
And I sent the email as promised.
She notified the judge.
Thank you. I really, really needed that. Thank you very much.
You're welcome, Mr. Myers. All right, we still have Archie, Bowie, Shealy, which is Shealy's a motion. So let's get it together.
Can we go ahead and do Bowie? If the state is.
That's fine.
Ready on that? I'm so frustrated.
That's what I've been dealing with for 6 months because on this other misdemeanor case, it's been just like that.
I'm back, Your Honor.
Okay. Mr. Myers asked for a continuance for 2 weeks. I granted it.
Okay. And Your Honor, is it okay if we can put his other case on the calendar as well?
Yes,
So we can
yes,
have it
yes.
on.
Yes,
So that
please.
other case that he has is 2024 CR 10867 for simple battery. Again, that case is 2024 CR 10867. And Your Honor, that is continued to the 30th. I'm sorry, the 29th.
Yeah, I guess that's the next two. That's Tuesday, 2 Tuesdays.
Yes.
Yes.
Thank you, Ms. Ponder. Thank you, Your Honor.
Thank you.
All right. Mr. Bowie, raise your right hand for me.
Judge, this
Oh,
is
I'm
a-
sorry. This is the motion for bond. This is not Mr. Bowie, is it?
This is Mr. Bowie.
Oh, okay. I'm sorry. Motion to revoke bond for Mr. Anthony Jerome Bowie, 2025 CR 03122.
Judge, it's
It's a motion to
set bond.
modify the set bond, Your Honor. It was continued. The state objected for it to hearing.
Oh,
to
that's
happen the
right.
same
I'm
day.
sorry.
Yes, Your Honor.
Motion to modify bond. All right, you're good, Mr. Bowie. All right, so it's the defense motion. Go ahead, sir.
Judge, so Mr. Bowie is held in custody with no bond on his charge. We had some discussion about this, but initially he was denied bond by the magistrate court because they had information that he was apparently on probation at that time. However, at this time, and I believe the state would concede this point, Mr. Bowie is not on probation in any jurisdiction, so he is not a probationer. So our argument is that provision of the code does not apply to Mr. Bowie at this time, and he is entitled to a bond on his misdemeanor case. I've also, Judge, from the time that Mr. Bowie has been incarcerated, he did lose his job. And I believe that under the bond code and additional amendments to that, one of the inquiries that the court needs to make in setting a bond is the defendant's ability to pay. So Mr. Bowie is indigent at this time. We're asking the court to set a very reasonable bond in his case. I believe that because of the charge, a UJR would not be, probably not be granted in this case, Judge, but we would ask the court to consider, because some of the new revisions to the code, Judge, but we would ask the court to consider setting a low bond so that Mr. Bowie can make it. The alleged victim in this case his son is currently on the call, and I would like to ask him some questions just in reference to whether he feels that Mr. Bowie being released would be would put him in any kind of fear, or if he's in any fear of Mr. Bowie violating his bond conditions there. But Joe, Mr. Bowie has not had an opportunity to get out on bond on this case. He does maintain his innocence. And
Okay, who's the alleged victim in the case?
his son.
How old is the son?
21
Where does he live?
with me.
Oh, not anymore.
Well, not anymore.
Who is currently in the house?
We don't have a house no more, Yana. We lost the crib.
He wants the what?
We lost our apartment right now. So he's currently living with a friend right now. He's living from friend to friend until I get back home.
And
Okay.
He is on the Zoom call, just so the court's aware.
All right. So, Mr. Bowie, I don't know what happened. But I will say this, it's hard for adults to live together. And I know a lot of people are in the financial situation. Just hear me out. You're looking at me crazy, but just hear me out. I've been doing this a while. It's hard for adults to live together. And you're looking at financial situations where people are like, yeah, we're gonna stay here. My adult son is gonna live with me in the house, and he's gonna help me with the bills, and we're gonna be able to do this. And a lot of times that doesn't work. And so I don't want you to say anything that might jeopardize your defense. But what I say is, a lot of times parents think they're doing the best that they can by either living with an adult child or having that adult child live with them in their space. But a lot of times, because you got two adults in a space, don't nobody want to follow anybody else's rules. It doesn't always work out like you think it should. And even though you think some of these family situations will blow over and they can be repaired by the time we get to this point, y'all have already made up or whatever. But the problem is, that's not how the court looks at it. Okay. And so sometimes you have to understand that even when y'all see it differently, like, that's just, we squashed that beef, it's water under the bridge. That's not how the courts look at it. Okay, so what I say is, sometimes it's easier for y'all, if it's a financial thing, for y'all to each get roommates and not live together. But you keep looking at me crazy.
Ms. Judge, can I say something, please? I haven't got a chance to talk at all.
Go ahead.
Situation. Like, my mother passed away down here. We came down here to Loganville, Georgia. My son and me is the only people we have. I never put my hands on my son. That's why my son is spoiled. He's 21 years old. I'm waiting for him to get his situation right, for him to get him a car and all that right now. I'm the breadwinner. I don't need.
But Mr. Bowie, what I'm saying to you is, he's 21.
I know, Judge. Everybody tells me that. That's true.
But I'd say it to so many parents, and then when y'all get in this situation, I'm supposed to understand that you ain't do anything and he's spoiled. I get that. But no, New York, hold on, New York. I get that. But what I'm saying is, as a parent and as somebody who was raised by a single mom, for the most part, I have a stepdad who helped raise me. The point is, a lot of times we spend so much time coddling these kids, and they never feel the rough side. And then when it comes time for us to discipline them, they buck up. And if you old school like me, you got one time to buck up against me, and I'm gonna put my hand through your chest. Now, I might go to jail, but I'm gonna put my hand through your chest. So what I say to you is, we keep saying, well, we're helping them, but are we really? Because what we're doing is making them irresponsible. Let me ask you the question. When did you leave home? What age were you?
15.
It's always the parents who left home at 15, 16, 17. I get you know how hard it is out here on these streets, but you made it. But you're going to coddle his 21-year-old butt. And then this is the situation you in. Y'all don't have a home because you lost it. You don't have a job because you lost it. And he is talking about, let my daddy out. Well, this is a situation caused by two adults who can't live together in the same house. And when you tell me, well, see, let me talk, I understand this situation much better than you think I do, because I see it all the time. And it's always the parent who loses, because even if the child goes to jail, the parent is trying to put money on their books, pay their bond, pay for a lawyer. What I'm telling you is, I get that it might just be the two of y'all, but two grown people sometimes, especially if they know each other, have difficulty living together. While you sitting there trying to prop him up to get himself together, what is he doing? Is he in trade school? Is he in college? Is he working?
Yeah, he works at Kroger. And I was taking him to work I hear what you're saying. Like, I'm taking him to work every day. Now he has to take an Uber. He works at Kroger factory. He's doing good. He making some money, but I was taking him to work every day and making him save his money so he could buy his car. And that's why, I have another daughter too. So he got kind of a little jealous of her, me teaching her how to drive. That's how we got into this argument. And that's how we got into this fight.
I get that. But what I'm saying to you is, he's 21. He is a full-grown man.
Yes, I understand that now, Judge, from being in here with a lot of 19, 18, 21-year-old killers that I'm in here with now. I understand that now. I didn't understand that before. Like you sound from New York, I came down to Georgia, and I ain't want him to be like me. Like, my mother left us some money, you know what I mean, to make sure he was good. He graduated from Grayson High School in Loganville. So, you know what I mean? Like, I couldn't afford to send him to college, so I was trying to make him get his age back. So
I get that, but even if you can't afford to send him to college, you know how I went to school? I took out loans. I worked 2 jobs in college. So it is not impossible to do. And while parents keep wanting to do everything, I had a job where as soon as I finished school, I was on the bus headed to my job. I worked that job, came home late at night, went straight back to campus. It was every single day, 7 days in a week. I was either working and in school or working or in school every single day, 7 days a week. I never had a break. So what I'm telling you is, he can do that, but you got to let him fall. A lot of times we as parents keep propping these kids up, and then it's to your detriment. Now, he on the call wanting everything to be all right, to tell me it's all good and I need my daddy to be out. But he doesn't understand that he needs to be out there making his life do what it do. You grown now. You don't owe him anything past the point of 18.
That's a fact. I know.
And so you driving him to work, you making sure he do this, you making sure. All we doing is making kids weak. When I was in high school, I had 2 jobs. So what I'm saying is, let's stop propping these babies up.
Okay.
Let's give them the opportunity to be responsible and do what they need to do. Because when we keep holding them up and they never feel the rough, they don't know what it's like. And then they're gonna buck up against you. No. Okay.
I understand.
So, I don't have a problem.
Can I say one more thing, Judge? What about the 30 days they just made me do and I have the paperwork that I wasn't on probation no more.
I got you, sir. Look, we'll take all that into credit. What I'm gonna do is, knowing the nature of the situation, as long as you and your son don't have any contact with each other, I will give you he has no bond on any of the charges.
No, Judge. Well, sorry.
Does he have a history of any kind?
He doesn't have a bond on the, I believe can you pull it up, Taz, what his bond situation? I know he doesn't have on the battery family violence.
That's all I see.
Yeah, that's right. That's the only charge that he does have. So he's
okay. So I'll give him a $1,000 bond on each of the charges. And he can do property. He can do cash. He can do bond company. I don't care.
Okay, Judge. So you want me to draft an order to that effect? Or,
yeah. As long as there's no contact with the son until this case is resolved.
Okay, and that's a $1,000 bond for the pending charge.
For what now?
That's a $1,000 bond per I believe it's 1 count.
1 count.
I'm looking at 4 counts.
Oh, I'm sorry, but so it would They're lesser included, right, Judge? So it would be.
What?
So it's like battery, family, the way we typically see battery, family violence, battery, simple battery. family
Yeah,
violence.
those four.
So those would be lesser included. So you want $1,000.
Okay, so then a $2,000 bond on the battery family violence.
Okay.
And the other ones, because I don't know how you want me to count it.
Well, so Judge, my concern, obviously I want the lowest amount for my client, but what I want to make sure that what I submit is something that the sheriff's office will understand how to, because he's only held on battery family violence. I understand that the accusation has.
Well, that I was talking to somebody at the jail recently about that, because I was trying to figure out how we're supposed to do it. And she was telling me that if we put the bond on the charge he's held on, then the rest of it should work out.
That's what that's
okay. Well, then revise that to be a $2,000 bond on battery family violence, and then the rest of them will work themselves out. If you have to split them, then split them among the four. If you don't, then put it on the first one.
Okay, Judge, I'll submit an order to you as soon as we.
Okay, so whatever would give him an aggregate $2,000 bond.
Okay, thank you,
Okay,
Judge.
all right.
Your Honor, is it possible if we can do the Shealy motion to revoke bond? The officer has been on the call.
I'm fine with that. I'm ready. All right, Mr. Bowie, you got a bond. You can go back to the sheriff's office. All right, and this is Mr. Shealy.
Yes, good afternoon. How you doing?
Good afternoon, Mr. Shealy. This is State of Georgia versus Gabriel Shealy, 2023 CR 06477. This is battery family violence count 1, battery count 2, simple battery family violence count 3, and simple battery count 4. This is a motion to revoke bond. And the state ready?
Yes, the state is ready, Your Honor.
Okay. All right, Mr. Bowie, you're free to go.
Okay.
All right.
No,
just do it as a motion.
I didn't, listen, I thought I was coming for.
Hey, Your Honor, this case is 2023 CR 06477. I would like to just bring the court's attention to State's Exhibit A for this motion to revoke bond. It was a bond order, which the offense is, I'm sorry, which the offense was battery, and the conditions were to stay away absolutely directly or indirectly by mail, email, pager, telephone, or third person from the person, home, workplace, and immediate family members of any witnesses, excluding but not limited to Janira Jackson, and I'll spell it. I am probably pronouncing it wrong, but it's Jeneiro Jackson, common spelling Jackson, not return to or go upon the premises located at 1367 Pine Glen Drive, Riverdale, Georgia. Another condition, the defendant may schedule an appointment with the sheriff of Clayton County to accompany the defendant to his residence or other location which he has been excluded by this order to permit the defendant to retrieve items of undisputed personal property. This appointment must be made within 10 days of the defendant's release. And then last but not least, the defendant must not violate any laws while on bond. This was ordered on April the 30th, 2023, and it was filed on May the 1st, 2023. The state, before I call my witness, would ask the court to take judicial notice. At this time, Your Honor, in addition, this order was signed by Magistrate Court Judge Hugh Cooper, Cooper. Your Honor, may I proceed with the state's first witness?
Okay.
Thank you. Officer, may you please raise your right hand? Do you swear or affirm that the testimony that you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Okay. May you please state your first and last name for the court and for the record?
Officer Devin Gosling.
Okay, and can you spell your first and last name, please?
DEVINGOSTON.
And how are you currently employed?
With the Clayton County Police Department.
Okay, and being employed with the Clayton County Police Department, do you have the authority to, do you have arrest powers?
Yes, ma'am.
Okay, and are you post-certified?
Yes, ma'am.
And I want to draw your attention to February the 17th, 2025. Were you post-certified on that day?
Yes, ma'am.
And did you arrive to the address 1367 Glen Drive, Riverdale, Georgia?
Yes.
Okay. And why did you respond to that location?
I believe it was a return call for a domestic situation.
Okay. And did you make contact with anyone on scene?
I did, Mr. Sheely and Miss Jackson.
Okay. And when you say Miss Jackson, what did you learn the first name of Miss Jackson?
Restate that for me.
What was Miss Jackson's first name?
I can't remember by heart.
Okay. And if you were to see a copy of your warrantless affidavit, would that help with your memory?
Yes, ma'am.
Okay, one moment. And just Officer Gosson, are you able to have access to your warrantless affidavit?
I can try to pull it up.
Okay, one minute.
I think I have it right. I've been trying to get in the system, but it's been acting up.
I'm not trying to talk to you. It's just I have
All right, Officer Gostin, I have sent you a copy of the warrantless affidavit.
I got it.
You don't have to read directly from it. It's to help with your memory, okay?
Okay.
All right. And so does that appear to be a true and accurate copy of your warrantless affidavit?
Ma'am.
Okay. All right. And so what was the name of the person with the last name of Jackson?
Miss Geneva.
Okay. And where did this individual live?
1367 Pine Glen Drive.
Okay. And is that located here in Clayton County, Georgia?
Yes, ma'am.
Okay. And you indicated that you responded to this location from an earlier call of a domestic dispute. Am I correct?
Yes, ma'am.
Okay. And did you ultimately have a conversation with Miss Jackson and Mr. Shealy?
Yes, ma'am.
Okay. And at that point, did you make an arrest?
I did.
Okay. And what did you arrest the defendant for?
Aggravated stalking.
Okay. And during your course of investigation, why did you arrest the defendant for aggravated stalking?
Well, Miss Jackson was able to provide a copy of a no contact order, no bond condition, saying that he wasn't supposed to make contact with her at all.
Okay. And what was the date that it was issued?
I don't have the exact date, but it was of last year in 2024.
Okay. If you need to refresh your memory by reviewing your affidavit that was provided.
It was that July 25th, 2024.
Okay. All right. Thank you so much. No further questions.
Cross-examination?
None at this time, Judge.
All right. May this officer be excused?
Yes, Your Honor.
All righty. Next witness?
Yes, Your Honor, if I can just have one moment. I believe that an officer was attempting to log on. Chief Henderson?
That's affirmative. She is logging on. I'll check back with her right now.
Okay. May the state proceed, please?
You may.
Thank you. Good afternoon, Officer Lamar. How are you?
Okay. I'm sorry for being late.
You're fine. May you please raise your right hand, please? Do you swear or affirm that testimony that you're about to give in this matter is the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
Okay. May you please state your first and last name?
Officer, Shavana Lamar.
Okay, and can you spell your first and last name for the court, please?
Yeah, Shavana, SHA, V as in Victor, ANNA, last name Lamar, LAMAR.
Okay, Officer Lamar, and how are you currently employed?
With the Clayton County Police Department.
Okay, and being employed with the Clayton County Police Department, does it give you the authority to issue citations?
Yes.
And does it also give you the does it give you arrest powers?
Yes.
Okay, and are you post certified?
Yes.
And on July 12th, 2024, were you in fact post certified on that day?
Yes.
On this particular day, you responded to a domestic disturbance at 1367 Pine Glen Drive, is that correct?
Yes.
And is that located here in Clayton County, Georgia?
Yes.
Okay. And who did you make contact with when you arrived on scene?
Miss Jackson, the victim that called called in.
Okay. And did you learn, I'm sorry, what was the first name of Miss Jackson? What was her first name?
I can't remember. That was in July.
Okay. And do
I
you
just-
have a copy of your report, Officer Lamar?
I do.
Okay, if you can just review your report for me, you don't have to read from it, just review your report and then let me know when you're done.
Geneva, Miss
Okay.
Geneva Jackson.
Thank you. And did you learn the relationship between Miss Jackson and Mr. Shealy?
Yes, it's her grandson.
Okay. And during the course of your investigation, what did you learn?
I learned there was an ongoing issue with him being heavily intoxicated and becoming irate with individuals in the house, including Miss Jackson. When I arrived the first initial time, he ran out the back door into the wood line, and we couldn't find him then. I came back a second time that night, and he did the exact same thing. So I wasn't able to make contact with him.
Okay.
Others in the house also stated that he gets heavily intoxicated and becomes irate and attempts to attack people.
Okay. No further questions. Thank you.
Examination.
None at this time, Judge.
All right. All right, anything else from this officer? Is she free to go?
No, nothing further from this officer, Your Honor, and yes, may she be excused.
All right, yes, ma'am, thank you.
All right,
Thank
thank
you, Your Honor.
Uh-huh.
Your Honor, at this time, the state has no other witnesses for this motion to revoke bond. The state rests and will just wait for closing argument.
All right, does the defense have anything to present?
No, Judge.
All right, argument?
Yes, Your Honor. So, Your Honor, the defendant had an order for bond with several bond conditions on April the 30th, 2023, in which it was for him not to return to Pine Glen Drive, Riverdale, Georgia, in which he picked up a new case on July the 12th, 2024. And also he has an outstanding case from February the 17th, 2025, and that is for felony stalking. As you've heard, Your Honor, the defendant is not to have gone back to the location 1367 Pine Glen Drive, Riverdale, Georgia, and he is not to violate any laws while on bond. However, the defendant has picked up two new cases against Miss Jackson and also Miss Genevieve Jackson. And also, I apologize, Your Honor, one moment. And also has another case for the stalking against Miss Genevieve Jackson. Your Honor, it appears that the defendant refuses to comply with any of the conditions that he was given back in April the 30th. And as of recent, he is still receiving new charges against family members. Going back to that location, they do not want to have contact with him because of the nature of the cases, and he has a tendency of doing certain things. And so for that, Your Honor, the state will ask this court to grant the state's motion to revoke bond.
All right, Mr. Lynch?
Your Honor, at this time, I would just leave the decision in the discretion of the court, as it, of course, is. We will, well, that's all we have for right now.
How old is this gentleman?
Is Mr. Shealy?
Yes, ma'am.
How
How old are you, sir?
33. 33.
Okay.
The
All right,
screen-
yeah.
The screen is off on the computer. I don't know.
She sees it. She sees it. That's right.
I know. I'm telling her how I'm looking at the screen now. It's on.
All right, so the court is gonna grant the motion to revoke. Mr. Shealy, when a court tells you not to go back to someplace, don't go back. Don't keep going back. Don't tell me. Because you were told specifically not to go back. So
I take my kids to school from their address. I'm basically not trying to get in trouble with the school. You know what I'm saying?
then you need to make a different arrangement, sir, because this is not a good look for you or your kids.
I understand that. I did not have knowledge of no PTO, and like I said, my kids go to school from their address. I'm just trying to do the due diligence as a father's man.
All right, well, motion to revoke is granted. All right, next.
And Your Honor, after I prepared this order for the motion to revoke bond, may I be excused? Mr. Tipton has logged on.
Yeah, that's fine. So the last two we have are the last one we have is the Archie. We've it's my understanding it's the petition. Is that correct?
That's correct, Your Honor. Ms. Chang filed a petition to revoke Ms. Archie's probation. And the petition states, the main point of contention is the defendant has failed to provide proof of completing 240 hours of community service. Our situation, I don't think would be unfair to Ms. Archie to begin with it, is she provided documentation.
Where's Ms. Archie?
She's coming out now.
Oh, okay.
The deputy's having a.
Well, can we wait until she comes out? Because she's supposed to be here for her hearing.
Yes, yes.
Ms. Chang, can you send me a copy of the petition, please?
That's what I was going to say. Yes, sir.
Thank you, Ms. Chang.
You're welcome.
And good morning, everyone. I'm sorry, good afternoon, everyone.
Good afternoon.
And I forward you over that information as well, Mr. Tipton, as well as the the community service letters.
Thank you very much, Deputy Chief Ponder.
You're welcome.
This main issue. They said last meeting document for February 19th.
I have the documents here in my property.
Okay, good.
What was the last one?
February 19th.
No, the last three.
Mr. Tipton,
Yes, ma'am.
you've received the documents.
Yes, ma'am. It looks like Deputy Chief Ponder just sent them to me. I'm looking at them now.
Okay. I'm sorry, I couldn't remember your name, your first name to send it over.
I got you. I'll send you an email shortly, so you'll have my email close by when you need it.
Okay, thank you.
Ensure when he was using the letterhead without authorization. During this time here, he was not authorized to sign off on community service hours when he was. And they don't have any record. You have cross-check with the director of process. That was after Ms. Chang.
Okay.
That was the documentation. She was trying to verify it.
Mm-hmm.
And that was the response.
Okay.
So you see,
It was, I see what's going on.
and
And I did not know this. This is all new to me.
I understand. He sent that in.
And Ms. Chang, can you actually send me the original order of or excuse me, the original
The petition.
petition? Yes, I'm sorry, I'm having a moment. I'm
Sure.
sorry. Been in court, been up since 3:30, been in court since about
Okay.
8:30.
I understand.
And find out what the judge wants to do as an option that we'd like to do.
Okay.
But it's going to be up to the
Okay.
yeah.
Well, I get a chance to speak to the judge.
Yes, if you like. You don't have to, but you may.
Correct. I guess I didn't.
Your Honor, I sent over that order.
I've been here since last Tuesday. We ready?
It's ready, Your Honor.
Yes, Your Honor.
All right. Ma'am, raise your right hand for me. Other hand. Do you solemnly swear or affirm any testimony you give in this matter will be true?
Yes, ma'am.
All right, you can put your hand down. You're before the court, State of Georgia versus Kiera Simone Archie 2022 CR 06616 for you entered a plea for driving under the influence on the 19th day of August 2024, sentenced to 12 months on probation. And this is your second hearing. You have 3 months and 27 days remaining. You failed to complete community service. You have failed to document verifiable proof of completing 240 hours of community service. You failed to attend AA and or NA meetings 1 time per week. The last meeting documented is February 19th, 2025, and you failed to pay. All right, tell me what's going on.
Your Honor, so to address the each of the items as prepared by Officer Chang, I'd like to start with the AA meetings. Ms. Archie has documentation in her possessions here at the jail showing proof of attendance. So she'd be able to provide that to the court once she has her belongings back. On the failure to pay is just the one payment for $15. She would be able to pay that immediately.
Yes, sir.
But finally, the main point of contention here is Miss Archie's 240 hours of community service. The circumstance is that Miss Archie performed community service and reported and had a log prepared that was provided to the probation officer to Officer Chang. However, it appears that the person that she was reporting to, she was doing community service for CPACs, that's Center for Pan-Asian Community Services. And she was reporting to an employee of that agency who was signing off on the log. She wasn't aware, but Ms. Chang later found out when she went to verify the hours that this person, Mr. Chopin, Mutasim Chopin, was not authorized to log hours or acknowledge them on behalf of the agency. And furthermore, that person had left the employment of CPACs in 2023. So there was some issue as to how Ms. Archie was reporting her community service. I found out after speaking.
Somebody who left in 2023 signing off on orders on hours that she did since August of 2024.
Yes, Your Honor, and I was just about to address that. Ms. Archie had previously had a sentence requiring community service out of Madison County. That was in 2022, and she completed those hours through CPACs in 2022, reporting to the same person. So when she received the sentence here in Clayton County to complete additional community service, she went back to the same organization and spoke to the same person that she had been working with. So she's performed the hours in good faith. We do not know.
What, he was just showing up to a job he no longer worked at just to help her out?
Well, she was reporting virtually, remotely.
I went to places and did community service. I donated clothes. I fed people. I did a toy drive. I did these things. And community service is not just something that I do just because I have to, but also because I want to. I'm trying to start my own nonprofit for it. So it was no issue. I'm sorry.
But our position is that Ms. Archie has completed the community service and did so in good faith. However, Mr. Schroppon may have not been authorized to report this and continued to allow her to report even when he was no longer a representative of that agency. We have no way of verifying that other than Ms. Chang did speak with or communicate with a higher up in the agency that said that he didn't work there and couldn't authorize that, and they had no record. So that puts us in the situation of having done community service, but not having it properly authorized and reported to the probation office. Ms. Archie has been doing AA meetings as required. In fact, she's done additional meetings. Told me that she's attending 2 to 3 meetings a week rather than just the single meeting required. She's completed a drug rehabilitation class. She completed the DUI class. I believe Ms. Chang would have knowledge of that based on her original sentence. And additionally, she's been working, supports a child, and a revocation at this point would cause her to lose current employment and have difficulty supporting her 5-year-old child. One last thing, she's told me that if it's necessary, if the court sees fit to not revoke her probation, she would go do additional community service to complete that requirement. If the court doesn't wish to acknowledge the work that she's done previously. If I summarize, kind of, I believe that covers everything, but Ms. Chang may have some additional information.
Ms. Chang?
Your Honor, I just emailed a copy of the community service paperwork that I received from Mutasim Chopin on April the 10th. And it includes the community service log from Morgan County. The dates worked there were January 8th, 2024 to February 21st, 2024, which is after
Well, she wasn't sentenced on this case until August 2024. Is that correct?
that's correct, Your Honor.
So why would I have the hours from before that?
Well, she's saying that she did community service for this probation in Morgan County in 2022, and that's how she knew about CPACs and Mr. Chopin. But this is dated January 2024.
I didn't,
I didn't say 2020.
I'm looking at information from,
It's it's in between all the other letters. It's like the
I see the Clayton County probation log
two.
and let.
It's the third, I believe it's the third page of that email.
Okay.
And then it has Judicial Alternatives of Georgia, Morgan County Probate Court on the log with probation officer Sarah DeGren. 40
And
hours.
he said Mr. Chopin stopped working here in 2023.
Correct.
Yet he's signing off on orders in 2025. I mean, on hours in 2025.
Well, I was put on probation in 2023.
Because I have a date, January 18, 2025, through February 6th of 2025.
Those are the dates for the hours for Clayton County, Your Honor.
Yeah, but they're signed off by Mr. Chopin,
that's correct.
who was no longer working there.
That's correct.
Hmm.
And I don't know if I missed something, but I don't know where Miss Archie is saying that she physically worked, because they only have this center in Atlanta.
He sent me to remote places. So
Where were those places?
It was one of private.
Just up here.
Your Honor, may the state question the probation officer?
You may.
Officer Chang, I didn't catch, did the court swear you in?
No.
Okay, please
I'm
raise your
sorry,
right.
Ms. Chang, I usually do. Do you solemnly swear or affirm any testimony you give in this matter will be true?
I do, Your Honor.
All right, go ahead.
Thank you, Your Honor. Ms. Chang, so we brought up Mr. Mustafa Chopin a few times. So who did you reach out to verify the documents?
So I reached out to CPACs at the number that was on the letters that were provided, and that I also checked online, and that's the number for that center for CPACs. And I asked to speak with Matasim Chopin, and that's when I was told that he hasn't worked there since July 2023. I spoke, at different times with different people. And
did you receive any email correspondence regarding this incident?
Yes.
Okay. Did you have reason to speak to a Miss Yari Mena? That's Yarimena.
Yes.
Can you tell me who Yari Mena is?
Yari Mena is the health program manager for CPACs.
And what did Miss Mena tell you about people signing off on CPACs logs?
She sent me an email, first of all, and then, when I spoke with her, she also said verbally that Mr. J. Shim is the only person certified to sign off on community service hours.
Did she tell you anything about falsified letterheads?
At one point, let me check my email. She said in the email that she doesn't know why Mr. Chopin would be using their letterhead without authorization. And verbally, she stated that there has been problems with this person, Mr. Chopin, using unauthorized, their, let me see exactly what she said. Their protective data.
And did she say that Mr. Chopin had ever been whether or not Mr. Chopin had ever been authorized to sign off on community service hours?
No, she just said that Mr. J. Shim is the only person that can sign off.
I want you
community
to,
service.
I want to bring your attention to that email, the first paragraph. Please review that and start with the sentence furthermore.
She wrote, furthermore, during his time here, he was not authorized to sign off on community service hours. That's correct.
Okay. And then you also spoke to Mr. J. Shim, is that correct?
That's correct.
Did he send you an email?
Yes, he did.
Okay. What did he inform you about Mr. Chopin's actions while he was working for CPACs?
I can just read per his email. He said he forged our logo and wrote the letters on behalf of our organization, and that this was a very unacceptable act.
Oh.
Okay. So based on what you've seen as a probation officer and based on what they told you, what's your opinion about the documents that were turned in by Miss Archie?
The letters, if you see the letters, they all seem like the same letter. They're just kind of tweaked as to the hours that she worked, but they state the same thing. They look legitimate because, they included the tax ID number. It was the same address and phone number that was, when I verified the location with the Secretary of State, everything looked fine. But when I, called CPACs, they couldn't verify the hours.
After speaking with CPACs and doing your investigation, do you believe these letters are authentic? Do you believe that the logs were authentic?
No, I don't believe they're authentic.
Are you aware of has your office taken out warrants, or are you considering taking out warrants regarding turning in falsified government documents based on this?
We have not done that, and I don't believe that's something that we do. I would have to check with our director.
All right. Thank you. I have no further questions at this time.
All right. Mr. Taylor?
Yes, Officer Chang, who provided the documentation? Did they come from CPACs to you or through Miss Archie?
The CPAC's letters and the community service logs were provided by Miss Archie.
Okay.
And then I received a fax after she was incarcerated from Mr. Chopin.
Okay, so
with the same letters, and it included the letter and the log that was intended to go to Morgan County, or it was.
Okay. CPACs is an approved organization for providing community service. Is that correct?
I'm sorry, say that again.
Is CPACs an organization that you would accept community service hours from?
Yes, they are a domestic nonprofit, so we accepted that.
Is this an agency that you have received community service information from previously for other defendants or probationers?
They are not on our community service listing,
Mm-hmm.
and I do not recall having received anything from them in the past.
Okay, the letters that you received, it's not a situation where you're comparing them to previous letters to say that they're inauthentic. It's just when you contacted the folks, they said he was never authorized to submit them. Is that correct?
That's correct.
Not yet. No further questions from Ms. Chang. Thank you, Ms. Chang.
Thank you.
All right. Anything else at this time?
Nothing from the state, Your Honor.
Your Honor, Ms. Archie would like to address the court. And,
Okay. Go ahead, ma'am.
Hi, good afternoon, and thank you for seeing me today. I want to start off by saying this information that I've been told today, I did not know previously. I did not know this at all. If I would have known this, I would not have worked with them. I've been turning in my logs monthly. I wish that she would have verified the first month, so that way I could have known the first month that this was falsified documents. The reason why I chose to work with them is because my friend told me that they let you work remotely and you could choose different places to work and do your community service at. So that's what I did. I did not know that this person didn't work with the company no more. I don't have a close relationship with them at all. I do have 3 months and some days left for probation, and I'm willing to redo the community service because, like I said, I don't mind doing it at all. I can redo it. I am sorry that this happened, and I wish that I would have known this myself in advance. For my AA meetings, I've been going to 2 to 3 AA meetings every week. I have not missed any. I have proof and documentation in my folders that I have here in my property that I was going to turn in.
Okay, but Ms. Archie, it's April, and the last proof that Ms. Chang has of you going to AA is from February. So where are all those documents?
So the documents that I have is for March because I only check in once a month. So I always bring in the previous month. The last time I checked in was March. So she has the February documents. This month is April, so I was bringing the March documents.
Okay. And how did you contact this gentleman to get him to sign off on your
Well, since I've started working with him, I send in my paperwork and he signs it and he emails it back to me, and then I print it off my computer and I bring it up here. Just like with my AA meetings, they email it to me, I print it off and I bring it up here. And as I told Mr. Taylor, I even signed up for a drug and alcohol.
Okay, yeah. Let's go back to why Mr. Sharpon would give you all these hours with nothing in exchange. Like, why would he do that when he knows that it's false and that could get you in trouble when he could have just let you continue to communicate directly with the company?
I honestly, I have no idea. I have no idea. That's why I say I wish I would have known this in advance. Like I said, I got to him through a friend that did community service with him in the past. Because they have remote, you could do wherever. Like I said, I did.
Well, I guess they do have, you can do wherever if he just faking it.
Well, see, I didn't know that. And I wouldn't be standing here right now if I knew that. I promise you I would not be standing here right now.
I'm sorry, Miss Archie. This is really, really unbelievable. Not hard to believe, unbelievable.
It's very unbelievable. And I understand that this is something on y'all behalf that y'all think that I'm lying about, but I'm just finding this out today. I promise you I'm just finding this out today. I had my family contact them and everything. That's why they was able to call Ms. Chang after I got here. I called my family like, hey, can you call these people and see what's going on? Like I said, I cannot.
Your Honor and Ms. Chang, I don't know if this was provided to you, but the CPACs indicate the leadership at CPACs indicate the reason for Mr. Chopin no longer being employed by them. It sounds like they had some problems with him, and his employment was terminated for some reason.
I get that, Mr. Taylor. but I'm cynical enough to think that nobody does anything for free. So even if she wasn't going directly to CPAC to get her information, why would somebody certify anything if they don't have it to, like, he's not working there. He's using their information fraudulently. So why would he waste his time verifying her information and providing her all these hours and signing off on all of that if he's not getting something in return?
Well,
Like, why would you, like, out of the goodness of your heart, falsify information?
I don't believe it. I mean, based on what I'm learning here, I think he perpetuated a fraud on Miss Archie and
In exchange for what, Mr. Taylor?
probably financial gain because she provided free services to a remote location that he told her to go to.
Where
Cleaning.
did you go, Miss Archie? Name some places.
Okay, so I've been to Gresham Park. I went to the Gateway Center off Prior. I went downtown and fed the homeless, we did a toy drive at, what was the place called? It was at a restaurant. It's off of South Lake by the mall. We did a toy drive there. It's like a sushi restaurant. They sell all kind of food. We did that. We did a coat drive. I mean,
And when you say we, who else was there?
it was other people there, including my friend that actually told me about the company. He was there as well. I mean, I don't know the people personally, but we were all there doing the same thing, collecting, passing out. I mean, I even bought stuff out of my own pocket, like toothbrushes, toothpaste, socks, and gave them out during the winter time. I didn't buy the stuff for personal gain. I did it just because I knew people needed stuff. I took clothes that I had from my home, my daughter's clothes and some of mine, and gave them away for donations.
Ms. Chang, what happened with her last revocation?
She was returned to probation after the service of 5 days, credit for time served, to continue attending AA meetings until probation ends.
What was the reason that she was on?
She was revoked because she tested positive for alcohol, Your Honor. That was on November the 19th, 2024.
Okay, here's the problem I have. So it says that he's sending this information from the Center for Pan Asian Community Services, but the cover sheet is a FedEx office cover sheet. If CPAC has an office, then one would presume that they have the ability with a computer to either fax or send it by email, but he's sending it from FedEx.
Yeah, I got all of the paperwork through email. I never seen anything from FedEx.
But I'm looking at a FedEx sheet. Like, where did that come from?
I'm not sure, ma'am.
And Your Honor, I do not have a copy of that
Yeah,
FedEx
I'm
sheet.
not sure.
I sent it. I just sent it.
Ms. Chang sent it.
I'm looking at the emails that Ms. Chang sent me.
I just sent it after we started the hearing, Mr. Taylor.
Oh, okay.
So it's a separate.
I see now. Well,
I have I don't know, Your Honor, if I could speak with you breakout room and with the attorneys.
Okay.
About a call that I received.
Okay.
If that.
And Your Honor, I'd like to, I've been doing a little digging while we've been having this hearing too. I'd like to also bring some things up to Your Honor's attention.
All right. Do we need a breakout room or can we just put them on the record?
Well.
Okay.
Breakout room.
All right. Breakout room, Mr. Tipton. Breakout room number 1. Courtroom is in breakout room number 1 and I'll join. So based on what I'm getting, I know there's fraud. And what bothers me is that nobody does anything for free. So if Mr. Sharpon is committing a fraud, which I believe he is, why is he doing this for Miss Archie? And even her going to toy drives and doing the things that she's talking about, those things aren't for pay. So, I mean, unless you were working in somebody's business.
Well, they may not be for pay, Your Honor, but it may establish Mr. Chopon's, I don't know, credentials within the type of community activism or like improvement for that community service. Those type of activities are supposed to provide based on what Mr. Tipton displayed under his LinkedIn profile. He appears to have some kind of pattern of working with organizations to assist people, and by providing a group of probationers to
He
various.
also claims to be a doctor of osteopath, and I don't see that.
I would just say that that's an indication of fraud itself. But that's neither here nor there. I just.
All right, this is what I'm gonna do, because this is difficult for me to pin how much Miss Archie knows. I feel like she knows, but it's not proof that it's not proof to a certainty for me. Miss Archie, you're gonna do 240 hours of community service between now and we're gonna have a check-in again in a month and a half, so 45 days.
45 days, you better have at least half of this done.
And you need to communicate with Ms. Chang about where you choose to, before you get started on doing any of these hours, Ms. Chang needs to know and approve where you're going, okay?
Yes, ma'am.
And it better be somebody who can actually sign off, or else if this happens again, because I don't know what happened with the other county that you worked with these people, but if this happens again, then I'm definitely gonna make sure that this gets elevated up to a felony upstairs.
Is the documentation, is official government documents, fraudulent documentation submitted to a government agency is a felony. Just, I want you to know specifically what you're dealing with.
Okay.
And how serious this is.
Yeah, because I've had people arrested before because they've come before me and they've given me false documentation, and I knew it was a felony. So I had the felony warrant done and then I was done with the case. Please don't make me have to do that, Miss Archie, because people who think that they're slicker than me, they just don't understand. I'm not dumb. And so if it doesn't smell right, then I'm gonna have an issue with it.
Yes,
We
ma'am.
clear?
Yes, ma'am.
Okay, I'm giving you the benefit of the doubt right now. But I really feel like nobody does anything for free. So if this man was doing this for you, then there had to be some exchange for something of value. So just be clear that nothing is free in this world. And if the judge tells you this is what you need to do, you need to do it in a way that shows that there's integrity in what you're doing.
Yes, ma'am. I will make sure my paperwork is approved before I turn anything in. I will make sure Ms. Chang approves of it and she can verify it before I even work with a company this time.
All right, so 240 hours, we'll have another check-in, a status report in 45 days. And then, so we're gonna hold the petition open, and we'll have another hearing in 45 days to ensure that you are compliant.
Yes, ma'am.
All right.
And thank you, Mr. I appreciate the court's patience and listening to our explanation.
And Your Honor,
Yes.
if she'll be released today, or
Be released today with credit for time served.
and if she would report to me on Thursday, April 17th
2 days.
at 2:15.
Report on 2:15 Thursday.
Thank you.
All right. All right, so that was our last event. Gonna be signing, so send me anything that you need signed, and thank you all.
Thank you, Your Honor.
Good afternoon.
Judge, is is Solicitor Brooks coming on, or what we're gonna do here? Do a little meeting tomorrow?
Yeah, let me, I'm gonna sign back in.
Well, let's find out if he's coming on. I don't see him.
Oh, if he does, then I'll sign back in.
Okay.
Or if he wants to, tell him I'll give him a call.
Okay.
All right.